of the Constitution of India. But either Mr. Handicap or Mrs. Monto, this application which is filed is at page 39. Is it is this an appropriate application? Because for Pata you'll have to apply under Vasundhara scheme. Is this a proper application? No.
In a format lordship, they have to apply in lordship.
You better take instructions. Come at 2 o'clock because otherwise we'll be able to. Your lead petition will be dismissed. If the application is not in the proper format, this is not an application which they can entertain for grant of Pata. Take instructions and come at 2 o'clock. Take instructions and come.
Item 9.
Yes, Dr.
May I please, Lordship? The petitioner before Lordship praying for restoration of the GST registration, which was cancelled by the respondents, Lordship.
Is there any bar for applying of the new?
In fact, that is the only option left, Lordship. With new registration, what will happen? The earlier business which was being conducted by the petitioner, the bills will not be paid for the works contract and all those things. Bills and the system of taking input tax credit will not be available to the petitioner, Lordship. In similar matters, Lordship, earlier this Honorable Court has passed orders where court has directed subject to payment of all the pending taxes and filing of returns.
There again, there's a you see, you have to show us material that up-to-date returns have been filed, because otherwise, if the returns are not filed, they'll not be able to make assessment and demand tax from you.
Yes, Lordship. Just because the registration has been cancelled, I am not being able to file the returns online. If they permit, I can file offline and I can pay the taxes subject to which they can restore it.
Let them take instructions. But this is something which is not workable now.
Because the online portal has been blocked, so I won't be able to file the returns or pay taxes also.
It's okay. Get instructions.
Yes, I will have the instructions.
Dr. Itodi, counsel for the petitioner, it is projected that the GST registration certificate of the petitioner has been cancelled with effect from
It is of November 2019.
November
6/11/19.
and the appeal filed by the petitioner was also rejected. Order dated 6/4/2024. Accordingly, it is projected that the petitioner is unable to upload his return he submitted that although there is no bar to apply for a fresh GST registration, but this will create create a situation where the bills receivable by the petitioner the input rate against GST on account of bills receivable by the petitioner would not be credited to his account. Hence this petition. You should notice reasonable. Give a date after 5 weeks.
After
5 weeks. Give it once and so. Mr. B. Goel, and
All respondents.
negotiable for the state GST, except notice on behalf of all the respondents. Formal issuance of formal notice is dispensed with. However, extra copies of the petition be served on him in course of the day. Next one. The learned standing comes for the GST. They'll obtain instructions into the specific plea raised by the petitioner prior to the next date of listing.
12th of June,
Get only this instruction, how it can be done.
12/06.
Item 1, time being.
Let us see what document you have filed. Give us a copy. You see, Mr. Sharma, you are giving us 1 page or 2 page of the agreement or the GCC or the amendment. We are not accustomed to read half of the document. If you want us to issue a notice, you have to give this. Otherwise, the requirement of law is that you will give the agreement in original, even if it is a 11.6 application.
Your
You will have
lordship,
to dismiss your petition.
your lordship in contract, in the whole the contract, only condition 37 or this is 70 is referred.
Please don't decide what we will read.
So I will submit the contract.
Otherwise, you will dismiss your application. It's incomplete. Without the full agreement, we can't entertain an application. That is a law.
Next date, I will give the full agreement.
Okay. The contract agreement filed by the petitioner is a petitioning person is incomplete. Most of the requirement of law is that to entertain an application under section 11(6) of the Arbitration and Conciliation Act from either the arbitration agreement or the certified copy thereof be produced in court. First, the petitioning person undertakes to provide the entire copy of the contract agreement on the next date. When do you want?
You may do last week of May, any fixed date.
Last week of May. Okay, list on 27/5/2024. Next paragraph. The petitioning person submits that an additional affidavit has been filed. You file it today. This you filed when?
It was on 25th, I said.
Okay, it was filed on 25th.
Yeah.
4/2024, which is not on record. The same may be typed on with the record. R. Devi CEC is present. This term.
27/5.
5/2024.
Item 10.
Lordship.
Yes.
Lordship, this is also a similar matter, Lordship, which has come up before your Lordship. The similar order is at page 65, Lordship.
Page
65. Paragraph 7, the order date is there, Lordship.
yes.
It will be 25/1/2024, Lordship.
Para 7. Date will be. Please give again.
Returnable date, any date?
No. Please give the date again.
25/1/2024, Lordship.
25/1.
2024,
2024 instead of 9/2. The rest is same.
Lordship.
Okay. Advocate and respondents are saved.
And for 3, 6, and 7.
3, 6, and 7 is same. Yes. Same. But you have received instructions in the meanwhile on
Yes,
these
sir.
matters.
Actually, we have received instruction. Section says that the department has power to send a sign. Now, Lordship
You
is
file
to
any
decide.
affidavit in any one of the cases?
In one case, we are filing a petition.
Okay.
Now, Lordship, court has to decide whether sufficient ground was there. I found on judgment, it says that, and department has power, and they can inform. Getting subordinate legislation.
Okay.
11.
Lordship, 11 and 12 are also similar matters. The order date, if I may please, Lordship, 11 is order date is 2/4/24. Sorry, Lordship, 5/3/24. Item 12, it will be Lordship 6/3/24.
6/3/24. Same date.
Lordship, item 11, 12, paragraph 4 needs to be omitted. Lordship.
Item para 4.
11 and 12, paragraph 4 perhaps might need to be omitted, Lordship. Oblige, Lordship.
Daily list. Item 15 for admission.
Please, your Lordship.
Just a moment. Just a minute. Yes, which were the respondents?
Respondent is my lord, the standing counsel of my lord. DCPL now.
Where is the, Mr. Thakur, you have come?
Yes, ma'am.
How's your health now?
Ma'am.
How's your health now? Okay. Where is the Jamabandi of your land?
Hello. Here. Here I'm appearing on.
You're not given. The reason I'm asking only one question is that the respondents have taken a stand that this 1 bigger 2 kata land which you claim to be yours was a land allotted to BPCL. If it's a land allotted to BPCL, then the question of compensation will never arise. The land was never acquired.
I'm just appearing on behalf of the Lieutenant member. So Lordship, we will file our affidavit in reply as he instructed. So Lordship, kindly.
In affidavit reply, you can't improve the case. When the court asks you questions, then you said you will find a reply. If you wanted to file a reply, that would be the first question you first prepare for adjournment you will be making. You are waiting for the reaction of the court. Then you make an assessment whether you will do the case or not. That's a big risk you are taking. Why you make me spend time? If you wanted to take adjournment, please take it, give us, have a list circulated to the court master. You see, that is why you invite trouble for yourself. Please don't take a risk. Because we may dismiss this petition, but ultimately it is someone behind you for whom we are to think. You make me spend time. I'm spending my family time to read this brief. That's why out of this brief, I've only asked you one question, and then you take an adjournment. Don't do that. The query of the court that the petitioner claims compensation in respect of land measuring 1 bigger 2 kata, whereas the stand of the respondents is to the effect that said land is a land allotted by the government to the BPCL or the Land Council for the petitioner. Pays for carried to its time to file affidavit in the plan matter. BG Talukdar, Senior Counsel, assisted by Mr. PPK. The counsel for the respondents is present. Just after 2 weeks.
Item 16.
Yes, who is appearing for the petitioner? What has happened, Mr. Talukdar? You have instructions about notice?
My lord, in fact, I have certain instruction, my lord. I'll go through it, my lord. Can it be some other day?
Okay. None appears on call for the petitioner. Mr. S.K. Talukdar, Counsel for the Corporation Department. And Mr. M. Khan, Leonard Counsel for Respondent 7 and 8.
7 and 8.
For the government, will be there? Will you speak with any government advocates?
Deputy Commissioner.
For the respondent 2 are present. on the prayer made by the standing counsel for the corporation department. No, just say that for enjoy justice, the matter stands adjourned today. List after,
My lord, next week, after a week, my lord.
okay. List after 2 weeks.
My obliged.
Any interim order is there? Any interim order is there? No.
Interim order hasn't existed.
No, no,
No, my lord.
there's no.
Item 17.
Lordship, I'm appearing on behalf of Mr. M. Adam for responding number 7. Kindly the matter may be taken up at 2 as the engaged counsel is on legs.
17
Item 17.
at 2.
Or any other day, my lord. I have some difficulty in the second half, my lord.
Just a moment.
Lordship, the matter is pending for last 2 years. Lordship, the respondent number.
Okay, it's okay. She's not taking an adjournment. She is merely wanting an accommodation. Mr. Datta, what is your instructions?
My lord, we have filed our affidavit from the chief executive officer, my lord.
Just except number 5.
My lord,
What is the steps you have taken thereafter?
my lord, for that, my lord, I have to take instruction from the commissionerate, my lord. What happened after this, my lord? Because after the lodging the complaint, my lord, one inquiry was made, my lord,
Does not it appear to be very strange?
my lord.
There is an English proverb. What would be the meaning here if I apply this proverb, hand in glove? What would it mean?
My lord, the secretary was involved, my lord. Thereafter, what happened, my lord? Lordship matter may be listed in the next week, my lord. I'll take instruction on.
No,
What
it's not that. If you see, you make an inquiry, you find that the work was done without any bill, voucher, without any plan.
No, those were not available, my lord.
Okay.
As per the report, my lord, those were not available in the.
Then you have planted some tree, and then flower will come, and then these documents will come out.
My lord, the secretary was involved, my lord.
No, I understand.
My lord.
But what prevented you, if you don't have anything, what prevented you from filing a, what you call this, filing an FIR?
Yes, my lord. I'll take instruction. Maybe FIR was lost or not. I have to take instruction on that, my lord.
No instructions. We'll call him in person, this video. If he comes, then he will tell us. He'll
One
ask for
opportunity,
personal
my lord.
appearance.
One opportunity, my lord.
Ask his personal appearance.
One opportunity, my lord.
Okay, let me record in the order
My
so
lord,
that he understands that we'll call him personally.
my lord, my lord. That can be done, my lord.
Mr. S. Aram, counsel for the petitioner. Miss
Bora.
P. Bora, counsel for respondent number
7.
7 is present. Petitioner's voice. So the deputy commissioner is PKMP government advocate appearing for respondent number 3. So as the third understanding counsel for the PNRD department appearing for rest of the respondents. So Miss that after the inquiry was made, when the secretary of the FAKALI Gaon Panchayat was found involved. He will go instructions as to the subsequent development. Next paragraph. We noticed from statements made in paragraph 4 of the affidavit in opposition filed by the Chief Executive Officer of Nagaon Zilla Parishad that during inquiry, no document like plan and estimate, bill, voucher, etc. related to the executed schemes were found available at the FAKALI Gaon Panchayat office. And therefore, inquiry officer could not ascertain whether the works has been done as per plan and estimate. Full stop. If even after that, next paragraph, no? Even after that observation, no further steps has been taken by the respondent number 5, we find that the proverb of hand in glove appears to be evident. Full stop. Accordingly, we were inclined to pass an order for personal appearance of the block development, of the Chief Executive Officer, Nagaon Zilla Parishad. No steps have been taken thereafter. However, on clear made by the Donor Standing Council for the PNRD department, we refrained to do so, just to enable him to obtain instructions. The next paragraph, the Donor Standing Council for the PNRD department shall obtain specific instructions from the respondent numbers 2, 4, and 5. And if no affidavit in opposition can be, no additional affidavit can be filed by the, no affidavit of the additional affidavit can be filed by the said respondents. They would provide appropriate written instructions to the Donor Standing Council for the PNRD department for being produced before the court. Downloadable copy. The Donor Standing Council shall send a download copy of the order to the said respondents. For doing the needful. Next, this on after 2 weeks, give a date.
Item 18.
Yes.
That's why I have received the communication. They're asking for some more time because of the election and saying election, they are, all the staff are busy.
Okay, when do you want?
My lord.
When do you want?
After 4 weeks, my lord.
Give a date.
Any date.
Always give a date.
5th of May.
Both sides are represented.
No, after election.
After 4 weeks.
12,
4
13,
weeks of, sorry.
12, 13.
Oh, sorry, 5th June.
5th June. 5th June. 15th June this year.
Let it be in the last month, my lord, because she is to receive the money, my lord. Let it be on the 20.
Okay, 27th then.
30.
Both sides are
Records
represented.
I am, lordship, I can access.
Hmm?
When without the instruction, I can access, but my lord, I need
Right,
some
okay.
instruction.
Okay. Both sides are represented.
20, 27.
On the instruct, upon instructions from Mr. P.K. Mehdi, Learned Government Advocate, Mr. B.J. Tarugar, Learned Senior Counsel, place for adjournment. On the ground that due to ensuing elections, he could not be duly instructed. Accordingly, matters stands adjourned today, list on 27/5/2024.
Item 21.
This is the reputation for against the demolition of Pacharav and Amkormat. Implement order is made page 29.
We've seen that. Just,
Page 34.
but as per the affidavit filed by respondent number 2, this is a part of the road which you have encroached.
Public road.
No. But I have submission, my lord. Implement order is passed, my lord, on, it is, my lord, page 34, my lord. Passed on, my lord, 29 June 22.
Yes.
This is, my lord, on the basis of the application filed by respondent number 7. The 7 was earlier precedent of the Namgor, my lord. And your lordship, C, my lord, his application, my lord, I'm reading, my lord. Page 21, my lord, lordship sheet, my lord. Page 21. How the matters comes, my lord. Emulation of a Batsara of a Namgor, which was the earlier, my old one. And that was also, Batsara was also constructed, but it is renovation.
You sure?
When it is renovation, my lord, the respondent number 7 made an application before a deputy commissioner.
No,
On his application, my
no,
lord,
Mr. Mahawat.
this order was passed.
Mr. Mahawat. Please show
I
us.
am, my lord, something, my lord.
Please a moment. Please for a moment. Please show us any document identifying the land where this construction has come up. Which patta this land construction has come up. Tell us specifically the dark number and patta number where
Yeah.
this construction
I
is
am
there.
submitting, my lord. Page 19, my lord.
19.
Page 19, my lord. Two kotha 6 lessa land, my lord. That is, my lord, government number.
So this is government land. So this is government land.
My lord, it is not declared a government, it was number was earlier was there, my lord. But it is the only basis of the order passed by the 100 deputy commissioner of marriage, it is not clear, my lord. Only the regarding only the Basra or construction of Basra. Basra was earlier there. But how the erosive sheet matter, how the respondent number 7 made an application where he was earlier president. Now his interest is matter on the construction matter, not more than that matter. He is only one person who is opposing, but whole villagers.
No, even if
on-
one person opposes
My lord.
and the government finds that the land is a government land and it is reserved for
yet,
road.
Not declared, not yet declared to be my government land matter.
I don't know, you are showing us
That
page
document
19.
Itself.
No.
Your document, page 19 itself shows that. Read page 19.
Right.
What does 19 say? You have shown us this document.
Right.
So it's a government land. So your petition has to be dismissed. It can't be maintainable. Even if there is one public spirited person who has told us that this is a government land, you can't have encroachment on a government land. You can't permit that. Even if it is Namgar or something else.
My lord, 50 years ago it was made, my lord. How will it
No,
go?
maybe
That
100
comes
years
now,
ago.
it is
But
standing,
please,
my
you
lord.
see,
What is standing, my lord?
Mr.
What is the
Mohammed,
loss of the government?
Mr. Nur Mohammed, you please tell us.
Only 2 kotha land, my lord.
It's not question of 2 katha or 2 inches, but if it is a government land,
Yeah.
even 2-inch government, 2-inch government land would be good enough to have it
My lord,
demolished.
the order was passed on, my lord. Your recipe order, what order says, my lord? Order says, my lord, there is a matter, discussion should be made between the 2 parties. Who are the 2 parties, my lord? And how I discuss is necessary, my lord, land is government land, my lord. Your recipe order, my lord, page 34, my lord. They say that there is a path. Actually, there is no path. Your recipe order, my lord.
I don't know, maybe my English is incorrect. But from what you have shown at page 34, I have marked it. This is this paragraph, incidentally, I marked it. It says he requested both the parties to remove the illegal construction amicably through mutual understanding. So it's not a question of fructifying or giving its imprimatur to the construction. It says remove. By both sides discuss and remove it.
Not the main structure, man. They have constructed, they have blocked the public road. That part will be.
Effect, my lord, putting the road, my lord. Telling the people. They're living behind the road.
Sir, my lord, may I submit, my lord, just a moment. Respondent number 7 is the main player in this case, my lord. Before that one, when he was the president of the number,
File a suit
nothing
for
was there.
compensation.
But when he was ousted,
File a suit for compensation.
Right.
If he's a wrong man,
my lord,
he'll pay compensation.
how the interest come next? There was a seat, my lord, the number, only 2 kotha of land of the maybe government.
Mr. Nur Muhammad, you see, I'll tell you my difficulty. I have repeated it not less than 100 times here, but today I'll repeat it for your benefit. Recently, I was not well. I went to a doctor. He checked me up and then told me that, sir, you don't have a heart. So my heart is not there. What to do, heartless man?
So the order is not my lord, the important order is my actually my lord.
No, we can't give an imprimatur to withholding of a government land. If it is Namgar, it may be a Namgar, it may be my house, but if it is encroaching on the government land, it has to go.
And the circular officer, annexer C also circular officer says the land, the Namgar is standing in the same land, my lord.
It's okay.
At that time, there was no question of demolition, my lord. When the FGC declared that the land,
Even
the
if there is
number
a
is
complaint
only-
and it's found to be a government land. It
there is
can't give.
no question of my lord, demolition or my lord,
No,
Right,
we
remove.
can't.
I leave your lordship, my lord.
Heard. Mr. S.K. Nur Mohammed. senior counsel assisted by Mr. Your name? A. Counsel for the petitioner. Also heard Mr. For revenue, Mrs. P.R. Mahanta, Leonard Chandika, the Revenue Department, appearing for respondent number 1, led by Mr. B.J. Talukdar, Senior Counsel. P.K. Mehdi, Leonard Government Advocate, appears for respondent number 2, 3, 4, 5, and 6. And Mr. N. Burman, Leonard Advocate, appearing for respondent number 7 and 8. Next problem. The petitioners, the petitioner claims that the Sensua, SENCHOWA, Bali Sapuri, Hati BHATI, Namghar at Mazuri, was established in the year 1887. Full stop. It is posited that during the year 2015 to 2021, under the then president of Parichalana Committee of the said Namghar, namely Ajit Hazarika, within bracket respondent number 7, to granting aid to the extent of rupees 4 lakh and rupees 9 lakh respectively, was given for development of the said Namghar and its area. The petition projects that the gate of the said Namghar, called Batsora, BATSORA, was old and in dilapidated condition. But the respondent number 7 did not incur any expenditure for its restoration. And therefore, under the presidency of Kanak Das, the Kanak Das of Sensua Bali Sapuri, Hati Namghar Porisalona Committee, the construction of the said Batsora BATSORA was started. Full stop. However, on a complaint made by respondent numbers 7 and 8, the District Commissioner Majuli held a public meeting on 29/6/2022, and a resolution was adopted asking the Namghar to remove the construction of the said Batsura on or before 27/20/22 and to clear the road to the nearby school. In this repetition, it is contended that there is an alternative road to the said school which is in use. And it is submitted that the said Batsura, which is an integral part of the said Namgar, constructed long back. And therefore, by filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking for setting aside or quashing of the minutes of the meeting dated 29/6/2022. Where is this minutes? Which is the document? Which page? Which page is that document? Meeting of the minutes meeting. 29/6 is the minutes. Where is that?
34, my lord.
Last page.
This is signed by the district magistrate Majuli. Within bracket respond number 2. Next one. The senior counsel appearing for the respond number 1. For the learned government advocate appearing for the respondent numbers 2, 3, 4, 2 to 6, and the learned counsel for respondent numbers 7 and 8. Also submitted that the land is a government land earmarked for a road, and the unauthorized construction affects the people at large in the area. Counting the said submissions, the learned counsel for the petition is learned counsel for the petitioner reiterated that the land over which the Patsura was constructed is pre-existing since the date of establishment of the said Namgar. However, it was old and in dilapidated condition. According to this, that the construction is not an old construction, but it's only a facelift given to the said Batsura. Next. It it is, it is noticed that in support of the writ petition, the petitioner has annexed as Annexure 3, copy of certificate number JKC, it's not 86 of the 2019, dated 11/1/2019, page 19, wherein it is certified that the land measuring 2 katha 6 lesha pertains to government, the government that. And the said certificate is purportedly signed by the circle officer, Ajali Revenue Circle. Full stop. Therefore, there is no dispute that the land on which the said gate of the Batsura was is existing and or being constructed is otherwise a government land. We find from a report dated 10/5/2021 issued by the additional deputy, the additional district magistrate, not report, it's the letter. In bracket Annexure D to the petition from a public complaint of about public complaint from the respondent number 6 and 33 others was received regarding unlawful construction being carried out on a public road. And the said authority have noted that noted in the field visit, the road was blocked by some person in association with the Namghar. And there are around 24 families who are using this road for the moment. And that the students, teachers, and guardians are also of a nearby LP school is also using this public road. The third stand is found to be reiterated in the affidavit in opposition filed by respondent. Number 2. Indicating that so clarifying in interview, clarifying that the certificate dated 11/1/2019 issued by the circle officer, Ajali Revenue Circle, reflects the name of the institution as BHATI, SENCHOWA, Bali Sapori, one word, BALICHAPORI, ST, KRISTI, Kendra, and not Bhati, Senswa, SENCHOWA, Bali Sapori, BALICHAP, one word, Krish, KRICH, one BUNDH. see, page 19. This is government that situated at Bhati, Sensua, Bari, Sapori, Christi, Kendra. Then this reply, huh? Next. Therefore, from the stand taken by the district magistrate, Mazudi, in the affidavit in opposition, comma, the land over which the Matsura of the gate is being constructed is a government land and is used as a road by the public. Next paragraph. Although the learned counsel for the petitioner has submitted that the Namkar is a religious institution and the structure is pre-existing. However, there's no document to indicate that the occupation of the government land or the said Matsura of the gate has the approval of the concerned respondent authorities. Like the district commissioner or the central officer. From the Land Revenue Department of the state. Therefore, comma, even if the Batsura of the gate is pre-existing, but the field report indicates that the said construction is obstructing a public road, comma, the private interest of the petitioner Namgar has to give way for the public, for public welfare and benefit. Therefore, the petition is found to be devoid of any merit and therefore the same is dismissed. The parties are looked to bear their own cost. Sorry, Mr. Lumabad.
Item 22.
Just a moment. Yes.
Partial to order that 7/9/22, my lord. A record has been produced by the respondent authorities, my lord. Last occasion, my lord, time was sought for by the respondents to produce the records.
My lord, the record not yet received.
Because, also they failed to order it at 7/9/20. Taking over position, they have to maintain and 7/6/22 minus, so 23 minus.
Just a moment. In your reputation, where is the document relating to LA case number?
My lord,
There's a land acquisition case. Where is that document?
my lord.
Apart
So,
from page 31.
so for the report, which is based upon by the respondents that have been, my lord, starts from page 73, my lord.
Page,
73, my lord. The report,
please repeat again, page number
73, my lord.
73. No,
My lord.
where is the document of land?
Document of land.
Because you want to compare it with from page 31, that is the LA notification.
So far, my right over the land is concerned, it is not dispute, madam. It's to matter that, so far acquisition of my land, I have no objection. So far surveying,
But then you see, this is a land acquisition case.
my lord.
What you call under the right to fair compensation. You'll have to apply for what you call apportionment of the compensation, making the party the landowner as a party, and then you move the authorities for.
Yeah, in this case, my lord. After receipt of the notice, my lord, I had my application objection, what therefore, my lord, hearing was taken place.
Right to fair compensation.
Hearing was taken place, my lord. I approached this honorable court earlier to this, my lord. Order is at, my lord, page 55, my lord.
Page
55, my lord.
yes.
Pursuant to this order, my lord, I approach the authority again by filing application.
Where is that? Where is that?
That application is 67, man.
57.
Sorry, my lord,
67.
67.
But where is where is the Jamabandi or Pata in respect of your land?
My lord,
You are not the owner.
I'm the owner. So
Who is
for
the document?
ownership part is concerned, there is no dispute. There is no dispute. So for ownership part is because there is no dispute. Dispute only in respect of the survey of the land. They have the respondents stated that before taking over position, before then in relation to the first notification, my land was surveyed, my lord. My objection was that no survey was carried out at that time. The respondent of relied upon the circle officer's report as well as the Lakmandar's report as well as the Governor's report that land was surveyed. But that land was surveyed, that report was related to 2016, my lord. In relation to the notification of 2019, my lord, no survey was carried out. Accordingly, my lord, on 7/6/2019, 23, my lord, order was passed by this honorable court, my lord.
I don't understand. You see, come to page 71.
My lord.
In
My
71,
application
there's an
was
order of the
rejected.
District Commissioner saying that there's no construction over that land
Yes,
or any zirat.
Right.
In that land during the joint survey carried out on so and so.
my lord.
Now, you are preparing the writ petition. Please come here. This order is of 2021. Correct.
Right.
Now in 2021. You filed this writ petition.
My lord.
Correct. So therefore, this report is created after this order of 24/2021. It
That
says 5/6/2021, there is already a survey.
is a lordship is correct. That order was passed
Yes.
when I approached the authority again in view of the order
Correct.
passed by the
I'm not
honorable
yet-
court.
I'm not yet over.
Yes.
You see, now this, the prayer in your writ petition is to quash order of 6/8,
6/8, my lord.
correct? But this report of the district commissioner this is not under challenge where it says that the field report finds that there is no Xerox. So once this report or order remains unassailed, your writ petition, I find it not maintainable.
So far that order is concerned, my lord. I have approved the Lordship Commission, my lord. That order is also annexed, my lord.
No. Where is that?
My lord,
Next page, Lordship. 72.
72, my lord. No, my lord, not 72, my lord. '72 was the direction issued by the deputy commissioner by the Lordship Commission for production of my lord, some documents, my lord. 72, my lord. In case number RR 12/2021. In that case, my lord, deputy commissioner submitted the parawise reply. Is 73.
Yes. This we have seen.
But so far, if your lordship taking into consideration with regards to the carrying out the any survey, then my lord, lordship may take into consideration the report submitted by the Gaobura, my lord.
Where is the survey report?
There is no survey report, but only the page 77 may kindly taken into consideration. That is the base. Basing on that report, my lord, the Latmandal has submitted a report. And basing on the Latmandal and Gaobura's report, circle officer has submitted the report of survey was carried out. 77 is the part, my lord. The report submitted by the Gaobura. That is why, my lord, on 7/6/2023, my lord, this honorable court passed this order, my lord, for production of report, record, my lord. May I read you also?
Which page?
Page 77, my lord.
70?
7, my lord. Annex 20, my lord.
This says that there was no tea stall there.
My lord,
It was after 2 years that they found that a tea stall
yes, my
was
lord.
started.
Lordship may take into consideration that part, my lord. After 2 years, from 2016, I have erected, my lord, some structure. Notification for acquisition of land was published in the year 2019, my lord. So at the time of 19, my lord, notification of the acquisition, my lord, and prior to that, I have, my lord, constructed some structure there. So as per the report of the Latmandal, as well as circle official, no Xerox was there, no structure was there. But 2 notifications were there, my lord, in 2016 and in 2019. So for 2016 part is concerned, I have no grievances. That part was completed. So for 2019 notification is concerned, this matter relates to the notification published in the year 2019. The Gaobura said in 2016 survey was carried out. But at that time, no notification in relation to this expedition was published. Basing on this report, my lord, the circle officer has submitted the report before the revenue in the RR case. So accordingly, my lord, on 7/6/2023, this honorable court has passed the order to produce the records on which date, my lord, the
Sharma, it's not acceptable.
my lord,
You see, a preliminary notification of land acquisition was issued when?
2019,
2009.
19. 19, 19.
19. It shows that notification, preliminary notification.
Paragraph 3 in my petition I have mentioned. Page 31, annexure 1.
Is 30
The first notification,
in 2020.
my lord. LA case was 1 of the 2019.
Yes. Then he has a case.
Lordship. No, no, that,
If your
report,
preliminary notification was issued in 2020.
Lordship.
You will have no business to have what you call survey made in 2016.
And that's why, my lord, the last occasion, the court, honorable court was directed to, my lord, produce the record. We already been communicated, my lord, record was not received. But given some time, my lord, I will produce the record first. LA case number, my lord, 1/19.
You see this document. It says survey of 2016.
Lordship.
In your affidavit, is there any clarity when this survey was done?
No, affidavit.
Affidavit had not been filed, lordship. That, directly, my lord, that, we asked to, my lord, produce that records, lordship.
No, this respondent of 5 is filed an affidavit.
5,
Respondent 5, lordship, is the central government,
Central
lordship.
government.
Lordship.
Now you look at page 108, that affidavit.
It,
At page 108, paragraph. Brief facts of the case. Cost of land acquisition 211. Deputy Commissioner requested the make deposit, and deposit was made in 2018.
2018.
So therefore, that is why I'm asking those questions. If the entire payment was made by the central government in 2018, there must be a survey which is pre-existing, and the land acquisition from what you call notification is pre-existing. How second notification came into existence? That is why I'm asking these queries are pinpointed for that. That's why I'm not being able to follow. I was not being able to follow Mr. Sharma. Nor I was able to follow the repetition. That is why I was questioning about 2021 repetition. Everything was doubtful because here compensation is paid in 2018.
2018.
Acquisition notification comes in 2020.
20, lordship.
How can that happen?
Let me produce the record also. Then the picture will be come out. Otherwise, my lord.
Was the CGC appearing in the matter? PKS Barwa.
CKS Borua, he might be in some other court process.
PKS Barwa, CGC. Have you understood why so many questions to you?
Lordship. They have been deposited in the 2018, lordships.
How can that happen? Because the central government will not pay unless there's a land acquisition.
Or even below that survey and other process.
No. Without final notification, without preliminary notification, the assessment of the land acquisition will never be made. How did this happen?
maybe typing mistake.
Mr. M.K. Sharma, Ranat, counsel for the petitioner. J. Handik Leonard, and also for the revenue department, for
I'm for the government, lordship.
government advocate appearing for the which respondent. What are numbers?
I'm for 3 and 4,
3 and 4.
lordship.
Before that, let me say Bhattacharya, standing counsel for the revenue department appearing for respondent 1 and 2. None appears on call for the respondent number 5. Next, from the affidavit in opposition filed by respondent number 5 from the commandant 34th battalion, battalion is BN, capital B, small n, comma SSB, Boroma camp, BARMA camp, comma, specific stand is taken that an amount of rupees 26, 56, 24, 971 towards land acquisition compensation for 211 bigha, 3 katha, 15 dasha, within bracket 70 acre, bracket closed, has been deposited in the office of the district commissioner, Nalbari, on 5/2/2022 in 2 phases. In the first phase, sum of rupees on instructions received from the district commissioner Nalbari, sum of rupees 17, 52, 10, 071 was deposited to RTGS on 25/9/2018 at Allahabad Bank, Balitara, BALITARA branch, within bracket Nalbari. Pursuant to in the second phase, on a request received from Joint Secretary to the Government of Assam, Revenue and DM Department, within bracket Revenue and DM within bracket LR, bracket close department, made a request to deposit the balance amount of rupees 9,04, 14,900 by letter dated 10/1/2022, and accordingly the said amount was deposited on 8/2/2022 to the account of the district commissioner Nalbari to RTGS as additional cost of land. Right. Nalbari district, LA case number 1 of 2019. However, next, however, the learned counsel for the petitioner has referred to Annexure 1 of the writ petition, and it is submitted that the preliminary notification of LA case number 1 of 2019 was issued on 29/1/2020. Next, if that be so, comma, we find that there is a contradictory information contained in order dated 5/7/2021 passed by the district commissioner Nalbari, No, not this. Not this, 22/10/2022. Sorry, letter dated 22/10/2022 by the circle officer, EU Revenue Circle, addressed to the Additional Deputy Commissioner Nalbari, in bracket, lecture 18. That is proves that the joint survey of the land with Lat Mandal, Forest and Agriculture Department was made in the year 2016. Next one. In the order dated 7/6/2021, passed by the District Commissioner Nalbari, there is a reference to joint survey of LR staff. And at that time, no structure and Zirat or concrete structures were seen in the Revenue Circle Officer's report. The date of survey is not mentioned therein. Accordingly, the query of the court is how the revenue authorities, including the District Commissioner Nalbari, are relying on the joint survey made in the year 2016, when the LA notification preliminary preliminary notification of LA case number 1 of 2019 was issued on 29/1/2020 within bracket annexure 1, declaration in the said case was issued on 4/2/2021 within bracket annexure 12. Next one. This court, while issuing notice of motion by order dated 7/8/2023, had directed the respondent authorities to place before the court the records maintained by them after proper survey and assessment of the subject dash plot before taking possession. In deference to the previous order dated 7/9/2022. Stop. This matter was adjourned on 14/6/2023. On 1/9/2023, the relevant records have not been produced. Next, therefore, comma. The district commissioner Narbari, within bracket respondent number 3, is directed to take note that the records which were called for on 7/9/2022 reiterated by order date 7/6/2023 has not been complied with. Therefore, the district commissioner Narbari shall take note that he is in default of obeying the order of this court, and which may invite adverse orders. Next, the court was inclined to compel the district commissioner Narbari to appear before the court in person to explain why the order of this court has not been complied with. However, the learned government advocate submitted that he was perhaps busy in the conducting of elections. Therefore, he prays for some time after the conclusion of the election for production of records. The learned government advocate shall send a downloaded orders of this court to the district commissioner Narbari to ensure that the order of this court directing production of survey records maintained the survey records and assessment of the subject lot before taking over possession of the land be positively produced on the next date of listing. In which adverse orders be passed. Which will be at the which we deem to have been invited by the respondent number P for non-production of the reports. Next, for a list on it 24/5 before 24/5. We give you sufficient time. Right. With
23,
23 and 20.
with 24.
May I please? Item 23 and 24, my lord, identical in nature, my lord, relates to deduction of forest royalty by the water resource department.
Yes, I've seen
In both the cases, they have filed the affidavit of opposition. May I pray, my lord, some time may be allowed, I will file the reply. In both the cases, they have also filed the packeting application. In that packeting application, I have filed the reply, my lord. May I pray that the packeting application that may be listed in the packeting application column, my lord. I may be allowed some time to file reply in the main reply.
One to agree, to agree.
Also as a represented. So he has article and counsel for the petitioner. Based for him. Do it within a week. My lord. Can it be on this
Thursday.
time? My lord?
Thursday, Lordship. For stay vacating petition, there is some urgency. Can it be listed on Thursday, Lordship, coming Thursday, on 2nd of May, Lordship?
You need to file a reply.
Yes, in the main.
The main case, he has to file reply, otherwise in stay vacating, he has already filed a reply. Lordship.
In matters like this, where there is the only issue is about the payment of
Lordship.
this, what do you call this, forest royalty. That is the only issue involved.
Yes,
You can hear and dispose it of both the matters.
Lordship, yes, Lordship,
Fix it on 7th of May.
7th is a holiday due to election.
7th is
7th will be elections. 9th of May.
9th.
So shall it at least 2 days, what do you call it, at least a day before you.
9th, my lord, I have some difficulty, my lord, prefix matter in state commission. Consumer.
And stay application, you see, otherwise. 2
Yes,
weeks,
my lord,
the
that is
time-
correct, my lord.
That is a adverse
Can it be on 10th, my lord?
10th. Okay.
10th.
Case file is granted. Time till. And time to file affidavit replying the matter. It shall be done at least 1 day prior to the next date of listing. Next para. Mr. Aram Das, then a standing counsel for the Water Resource Department, has submitted that IA 376 of 2023 and IA Civil 86 of 2024, which are filed for getting the interim order, is pending disposal. So okay, he submits that the interim order is creating difficulty for the department and expresses urgency in the matter. Next paragraph. The issue relates to deduction of forest royalty, and therefore it is made clear that if the writ petition cannot be heard on the next date of listing, comma, the prayer for vacating the interim order shall be taken up on the next date.
Right.
Next part, list as agreed to by both sides, list on 10/5/2020.
Not the interim order that may be completed.
Interim order extended. Till then. Interim order passed to list transaction till then. What is the interim order? I did not see that.
Not to deduct the forest royalty.
Yes. In fact, they have deducted even after the stay order, and we have come up with contempt petition.
Interim is separate.
Yes. Always.
Item 27.
Please, Lordship. Lordship, I have received the affidavit in opposition filed by respondent number 2 and respondent number 5. Lordship may seek some time to file a reply to the petitioner.
In fact, there's no, we don't want to keep this writ petition pending. This has to be dismissed. If there's a land or a mutation of land,
Yes, Lordship.
you'll have to approach the, you'll have to go in appeal. There's the remedy prescribed. We can't take up land revenue appeals here in the writ petition.
And withdraw. I want to withdraw it. No, withdraw with liberty, Lordship.
Pardon me?
Withdraw with liberty, Lordship.
Ah, yes.
Yes, Lordship.
Take that liberty. Okay. Uh, your name is D. Angana.
Yes.
Ms. D. Angana, and counsel for the petitioner. Also, for revenue, you will be appearing Mrs. P.R. Mohanty on that standing counsel for revenue department, appears for respondent number 1.
I for a respondent number 5.
No, just only. Mr. J. Hendrick, government advocate, appears for respondent numbers 2, 3, and 4. And Mr. U.S. Borgohead and the council appears for respondent number 5. Next paragraph. In this writ petition, it is projected that his father, that a land measuring 2 katha 10 lecha covered by dag number 359 of pata number 261 of which place of village Khubalia, Khubalia, on PO. No, not PO is not required. Moza Dhemaji. Was standing in the name of his father, late Sukheshwar, Sukheswar Gogoi. However, the said land was illegally mutated. And it is alleged that the said land was illegally mutated in the name of respondent number 5, namely Kushal Gogoi, Kushal Gogoi. Stop. Although the petitioner submitted representations before the District Commissioner Dhemaji on 18/5/2022, 1/7/2022, and 17/10/2022, as no action was taken, the present petition has been filed under Article 226 of the Constitution of India. Next paragraph. We find that the Assam Land and Revenue Regulation contains specific provisions for filing of revenue appeal against order of mutation passed by the land revenue authorities in the district. And next, on a query of the court, the learned counsel for the petitioner has submitted that formal appeal was not filed, but representations were submitted on 3 occasions. Next paragraph. We also take note of the nature of grievance raised in the representation dated 18/5/2022. Next paragraph, be that as it may. No, sorry, 1/7/2022. Be that as it may, as alternative remedy is prescribed in the Assam Land and Revenue Regulation. And moreover, the where is the Jawabandi showing that mutation? Where is that?
Jamabandi copy is page number 17, Lordship. And Lordship, in page number 18, the Jamabandi copy of the name of the petitioner father is there.
Where is the order passed by the where is the order passed by the circle officer? Where is that?
Where page, Lordship?
Huh?
They have challenged the order dated page 17, the last order, the Soprovica Tini Dui,
Where
whether
is that
price,
order?
Namdai Long so and so.
Where is that order?
That order was challenged by them.
Where is that order?
But they have not annexed the order, copy of order,
It's not annexed.
not annexed.
You have a copy of that order with you?
I have no copy, but I have filed a uh, affidavit in opposition and I have annexed the registered shell deed. That this portion of land purchased by the respondent number 5 for registered shell deed, there is no violation of any kind of law, Lordship. After getting the POPA NOC from the deputy commissioner, the registered shell deeds were executed and accordance with the registered shell deed, the land has been mutated in my name. And my name is shown in page 17, para 4, Kukhal Gogoi.
You produced a copy of seal deed? No. You produced a copy of seal deed?
Yes, I have in my affidavit in opposition
Page.
in page number 8 onwards, 42, 43 onwards.
Seal deed is not there.
This is certainly Lordship, page number 43. My affidavit in opposition.
Your affidavit in opposition starts from page 43.
Start from number please.
Hemadhar Gogoi, who is he? Who is Hemadhar Gogoi? He is the petitioner.
Petitioner.
Petitioner. Son of Professor Gogoi. Here is a petitioner's father is a vendor of CL number 3. Name has been shown. First one is Lilambar Gogoi, second is Kalia Gogoi, and third vendor is Sukheswar Gogoi, father of the petitioner.
We also take note, next para, we also take note of the stand of the respondent of 5, wherein he is claiming that the land was purchased by sale deed, registered sale deed number 21, dated 6/1/2022, on payment of valuable consideration. Comma. If the petitioner wants to assume the same, there are other alternative remedies available in law. Next, in view of the alternative remedy available, comma, the issue regarding mutation, comma, as presented from the facts of this case, appears to be a disputed question of facts which the court will not entertain in a writ petition. So accordingly, this writ petition stands closed with liberty to the petitioner to avail such alternative remedy as the petitioner may be so advised in accordance with law. Take a break and come back.
Affidavit, today he is filing this affidavit lordship as per my instruction. He could not come due to some personal difficulties, lordship.
Okay.
We have not received the copy, milords, as far as it is only appointment, milord. What
Okay, but
objection, milords, they have, milords, I am coming on that aspect, milord. There is a arbitration clause, there is a dispute. I am within time. Milords, what objection, milords, will come? Milords, either it is time bar, milord, then they will file the objection, milord.
You'll have
And
to wait for some
specifically
time.
you on last
No,
date
no,
of
no.
hearing.
You'll have to wait for some time. Let me learn some astrology and then address you what they will take.
Sorry, milords, sorry.
No, it's okay. It's only a question of learning astrology. You can predict what is coming.
Sorry, milords.
Huh. But you should have told him because he's from auto station. Should have told him.
That's it.
Well, wherever it is unproductive traveling, nobody will like it. You
Today is
take your
filing
convenient time when you want.
Milords, any date, milords, then I will come again, milords.
Give a date when you.
Milords, after 10 days, milords.
Okay. Both sides are represented. Ms. R. Devi, CEC submits that the affidavit in opposition is being filed in course of the day.
Lordship, today, lordship.
Huh? Okay.
Today they will file, lordship.
Okay. You take his email address and mail it to him.
Lordship.
Next para. No, not continue. So that soft copy thereof shall be emailed to the address of the petitioner, counsel for the petitioner. Next para. List on. Tenth of May.
Lordship.
It will be okay for you?
Yes, milords. Milords, after 10th, milords, any date, milords.
Okay. 13th, then Monday?
It's all right.
13, 5/20/24.
Obliged, lordship.
13.
Item 29.
The matter may come out after some time.
After some time. Okay.
Item 30.
Please, lordship. My lord, I have appeared for respondent number 5, my lord. Lord, 2 weeks time may be allowed to file my affidavit in opposition.
Okay. Both sides are represented. Mr. M. Hussain, the counsel, preparing for respondent number 5. Respondent is granted 2 weeks time to file affidavit in opposition in the matter. Interim order passed today, stand extended to the next order listing, based after 2 weeks.
Only thing, my lord, my name is shown wrong, reflected wrongly, my lord. That is why it is difficult. Because this, my lord, my name M. Hussain H.O., my lord. That letter H.U. is difficult. Sometimes I left my lord.
Okay.
M. Hussain H.O., my lord.
Okay. The registry shall make correction in the spelling of the learned counsel for respondent number 5, as he spells his name as M. Hussain Hossain and not Hussain.
My lord.
That in the because this by listing the matter next.
Obliged.
Item-
Inform Mr. Well, we just inform him if his name is wrongly listed again next date. Inform him.
Last occasion was better was listed 3 was not again.
No, he's saying the name is
Oh, yes.
spelled wrong. He may miss it. He's informing.
Obliged.
Item 31 to 33.
There in these 3 cases, my lord. My lord, as per my instruction, my lord, in all the cases, money has been released, not dispersed. They have, the railway authority has deposited the money before the district commissioner Gwalpara. And my lord, district commissioner Gwalpara has not released dispersed. As because, my lord, as per my instruction, election is going on. After election, they will disperse. Lord, may I say, my lord, maybe dispose of, my lord, with the direction, my lord, deputy commissioner, since.
Let me see what the instruction. Yes, what is your instructions?
My lord, from the already deposited in the DC office. I have received the instructions, your lordship. The notices were sent to them for giving the amount, lordship, that they have not yet come.
Mr. A. Manaf, counsel for the petitioner is present. Mr. H. Sharma, the additional senior government advocate, has produced a copy of instructions dated 22/4/2024, indicating that
That
The-
serial number
the-
2, lordship.
the land acquisition compensation has been received in their office, and notice dated 18/4/2024 have already been annexed, have already been sent to the beneficiaries. Next, in 2 weeks, in view of the said. In view of the said instructions. The court is inclined to provide that letter photocopy of this given to Mr. A. Manaf, land counsel for the petitioner. And probably on appearance of the petitioners.
May I suggest, lordship? Let them approach us because notices
That's
are.
what we are
already-
saying. That's what we are saying.
Lordship.
And, according to there should be no impediment on part of the district commissioner. Collector Gwalpara to disburse land acquisition compensation to the petitioners on their appearance before the designated officer under the establishment of the District Commissioner Gwalpara for release of the compensation amount. The petitioners are permitted to produce a certified copy of this order before the office of District Commissioner Collector, together with photocopy of notice issued to the issued to the petitioners. Post. The learned senior additional senior government advocate shall also provide a photocopy of his instructions to be retained in record. Post. In view of above, this petition stands closed with liberty to the petitioners to approach the office of the District Commissioner for collecting the land acquisition compensation.
Increase, no?
Just a moment. Mr. Sharma, here we have two of Selen Basumatari and Rajan Rabha.
Yes.
There is a third lead petition of Paniram Rabha.
I'm sorry, five.
In all the cases, now that we have.
No, he has given me tools, so therefore I am asking.
Lordship, regarding that item number 31, I have received that instructions, but item 32 and 33.
No, in 31 and 32, you have received instructions. This is,
No, in 31, Lordship.
no, Selen Basumatari is there.
So, yes, 31,
sorry.
Lordship, this, yes, both the
So
petitioner.
this is Sarban and Rabha. So this disposes of then one only.
Yes,
The other two you'll have.
other two I will have to.
Yes, two. Okay. Only one of them, 31.
Though they have stated that they have already deposited the amount, most probably the same instructions
Yes.
will come, but even then, Lordship, let it be kept
Because
pending.
you see, the difficulty is that
Yes.
once you pass an order, then there is a contempt.
Lordship.
We don't want that.
Yes, Lordship, I agree with your Lord.
When do you want? Yes.
For 1 and 2. In Nazareth, item number 31.
Okay, item 31 is as Bhagwan government advocate agreed for responding 1 and 2.
CVC, Malad.
And Mr. Sharma, you will be appearing for, what's his, you see CGC for responding 1 and 2.
I am for 4, Lordship.
You will be for 3 and 4.
3 and 4.
Yes.
And in item 32 and 33, my lord, I appear for 1 and 2. What are the will be called?
31 and 32.
32 and 33.
Just see outside are represented. On the prayer made by Mr. H. Sharma, then additional senior government advocate. Just after 2 weeks, so as to never in
Lots.
31 is disposed of. You please give
Lordship, mind that instructions may be kept as a part of the record.
give a photocopy. This is the original one. Give a
Lordship.
copy and give it to him also one copy.
Lordship.
Take it from Mr. Sharma.
Obliged.
34. Yes.
Lordship, maternity lordship, eviction lordship, has been also petitioner died or lordship?
Just a moment. Just a moment. Just- Where is your where is your statement in this writ petition that you have not applied for motor accident claims tribunal for compensation?
Lordship, notification Lordship, page number Lordship, represent 26 Lordship, 26, page number 26.
Pardon me, 26.
Yes, sir.
No, that is not the question. The question of the court is, where is the statement in the writ petition that you have not applied for motor accident claims compensation?
I don't think it's there, Lordship. Page number Lordship 15 Lordship.
15.
Yes, Lordship. Notification Lordship.
He is not asking for notification. MSCT apply করছেন,
No, please try to understand. You see, a long time to go in profession. Please understand the query. We are asking you a question. It's not for nothing. We are asking you a question. Where is the statement in your writ petition that you have not applied for motor accident claims compensation? You have understood the query?
Yes, Lordship.
You have understood the query? Okay, then we pass an order. Don't worry. If you don't understand, you can't respond.
Lordship, I understand, Lordship. Lordship, para number 6, Lordship.
Para number 6.
Yes, Lordship.
It's not the answer of your Lordship's query.
We can't help it.
apply করছেন, নাই করা
We can't help it.
Statement
We can ask questions, we can't get, we can't expect or what you call reply.
No?
What's your name?
AK Das, Lordship.
Mr. A.K. Das, learned counsel for the petitioner. And Mr. Ed Sharma Lanet, additional senior government advocate. appearing
3
for
to 7. 3 to
respondent
7.
numbers 3 to 7. And Ms. P.R. Mohanty Lanet, standing counsel for the revenue department, appearing for respondent numbers
1.
1.
And my learned friend, he can appear for 2 Lordship.
Okay.
Finance.
1 and,
Yeah,
Mr. P. Nayak, standing counsel for the finance department, appearing for respondent number 2. Next para. It this by this writ petition, comma, in light of notification dated 15/11/2014, comma, the petitioner projects that her husband, late Partha Partha Kaur, had died in a on in a road traffic accident on 2/11/2015. Full stop. It appears
Oh, they got him. Notification got him.
from FIR dated 2/12/2015. That the that it is alleged that the deceased died in a road traffic accident involving a motorcycle bearing registration number ML 096233. Next paragraph. normally when there's a traffic accident, the concerned police authorities of the concerned police station is mandatorily required under the provisions of Motor Vehicles Act, 1988, to provide an accident report to the jurisdictional motor accident claims tribunal, and the next of kin of the deceased is also entitled to a copy of the said report. Next paragraph. In this writ petition, there is no statement as to whether the petitioner or any other next of kin of the deceased have made a claim for compensation before the Motor Accident Claims Tribunal. Full stop. Next paragraph. In the case of Reliance General Insurance Company Limited versus Shashi Sharma, SHASHI, SHARMA, the Supreme Court of India has held, amongst others, that pecuniary advantage from whatever source must correlate to the injury or death caused on account of motor accident. Full stop. Therefore, and next paragraph, therefore, the query of the court is that in the whether in under the facts and circumstances of this case, when the accident involves a motor vehicle, not only a claim made under the motor made before the Motor Accident Claims Tribunal, and compensation in form of ex gratia payable in light of notification dated 15/11/2014 correlate to the same motor accident. Full stop. If that be so, then then whether general principles under common law of damages will be adjustable under the compensation payable under the Motor Vehicles Act is required to be determined. Full stop. Next paragraph. Therefore, the learned counsel for both sides shall address the court on the next date of listing on the said aspect. Full stop. List after 2 weeks.
Thirty-five.
Should this matter may be adjourned for a week?
Just a minute, please.
This matter may be adjourned for a week, madam.
Just a minute.
My senior is unable.
Just a minute.
correction.
Okay. After a week.
And that apart also, my lord, I have placed a communication.
You have seen that
Yes,
it's
yes.
reflected in
So-
the previous order.
Yes, yes, there is no contemplation for any kind of eviction, man.
You don't know because this is something. Today it is not there, tomorrow it will not be there. That is not your
So, my lord,
instruction.
the instructions are very clear, my lord. See, though it's not
No,
written.
no, no. We have seen so many things. in this law. Today you say something, tomorrow something else happens. So we want some sort of insurance for tomorrow. Correct.
After a week.
Okay. Outside the represented, list after a week is paid for by land council for the petitioner. Because we are not granting any interim order till now, so that let us take it after a week.
Right.
36, 37,
Item 36 with 37.
you file your affidavit.
Yes.
Item 36 and 37 are
Okay,
another.
you are relying on the earlier affidavit, other affidavit in the other case.
Yes, Lordship.
Okay.
In item 37, we have filed our affidavit, and I think Lordship that will cover the
Okay.
36 also.
Okay.
And they have filed reply also.
Okay.
We have filed a reply, my lord.
Yes.
But it is not in the record.
It's not come to record.
I cover in the next week, my lord, on 10th of May.
Okay, also is a represented. Affidavit in reply. Filed with the petitioner in WPC 4303 of 2023 is not on record. It was filed when?
On 23rd of April.
On 23, filed on 23, 4, 2024. So let this said affidavit be taken on record. List on when?
On 10th of May, my lord.
10th May. Okay, list on 10/5/2024.
Minor correction, my lord. On last order, 8-4, it was mistakenly submitted, my lord, rejoinder affidavit instead of affidavit in reply.
8/4.
8-4. On the last order.
No, that's okay, we understand. Let it be rejoinder or something. It doesn't matter. Once it is the petitioner. You understand that? Okay.
Much okay.
Item 39.
Lordship. Lordship, in this case, we need some more time to file our affidavit, Lordship.
Okay, how much time?
So 2 weeks. 2 weeks.
Okay. What's the represented? Mr. C. Sharma, and Water Council for Water Resources Department pays for is granted 2 weeks for the time to file affidavit in opposition in the matter. List. Give a date after 2 weeks.
Thirteen 5. Item 40.
My friend, if you are.
Wait, wait, I am applying for respondent 9 and 10, Milord. I need some time to file affidavit.
Just a minute. Yes. You have instructions in the matter? No. Who's appearing for revenue department here? You will be appearing. You have any instructions?
No, my lord.
No. Sorry.
I'll send a reminder.
No, because you see, the allegations are twofold. Number one, that there is a big industry which is polluting. Second is more serious. It says that it is set up in a government land. Weeks. Okay. All sides are represented. The case projected in this petition is that not only a big industry has been set up by the private respondent numbers. Private respondent number 10.
9 and 10.
Hmm?
9 and 10. I reckon.
9 and 10.
9 and 10.
Which is polluting, which is causing pollution in the area. But it is also alleged that the big industry has been set up on a government land.
Private land as well as government.
As
Personal and the government.
As well as government. Just stop. Therefore, the court expects that the Pollution Control Board from a revenue department as well as the district commissioner shall file the affidavit in opposition on time. On the prayer made by London Council for respondent number 9 and 10, as well as on the prayer made by the London Government Advocate and Council for the state respondents. Matter stands adjourned today.
Maybe 3 weeks, my lord.
We are fixing it on 22nd of May. We have sufficient time by then. Elections would be over, you will be 25, 22, 24. So if for some reason the state respondents are not able to file their affidavit in opposition, at least they shall be they shall provide suitable written instructions to their learned standing counsel, the government advocate. Next one. The court permits the 11th government advocate and the respective standing counsel for the respondents to send a downloaded copy of this order to the responding authorities to get appropriate instructions by the next date. Based on 22/5/2024.
Much of it.
You also filed a affidavit by
I'll
the-
file.
41 with 42.
My lord, in 42, I have filed an affidavit. In
Just a moment.
41 was filed later in point of time, my lord. In 41, my lord, if your lordship accommodates me for a week, my lord.
Quite
I'll-
urgent, my lord.
In 41, I
file
wish to
this-
file an affidavit, my lord, because of the election and the Bihu vacation, my lord, we could not file an affidavit. Maybe 2 days time, my lord, I'll file it, my lord. Next Thursday, if your lordship takes it up for disposal, my lord, I am obliged, my lord. Next Thursday, if your lordship takes it up for disposal. Just because they've come up with some new,
We'll take
please,
it
my
up-
lord,
We'll take it up, but for disposal, we can't say.
my lord,
It depends on tomorrow is another day.
my lord.
Yes. Mr.
Malad,
Khan.
there is an prayer for interim order, Malad, since the chairman is facing no confidence motion, my lord, and there is some manipulation of records by her, records even received by this court. It will be the government advocate. And there is a prayer for interim order. If they take time, my lords, then we'll have to pray for interim order, my lord. Let not the funds be diverted unilaterally without compliance with the section 60 and 61 of the Municipal Act. Because any fund to be diverted, used for any use, should be passed in the board's meeting, my lord, under section 60 and 61.
No confidence motion is
Yes.
against respondent number 7.
Yes. Yes,
What-
appeared
what is-
for submission
what is-
complete.
What is your interest?
My interest. We have brought no confidence motion, my lord. In the midst of the motion was going on, my lord, we were picked up by police illegally at the instance of the respondent 7, and it was disturbed. And then later we were picked up and taken away to Thana. Then she says we have passed no confidence motion. How can that be? And the SPS filed the affidavit saying that there is likely to be a right and law and order situation. We have to pick. If you want to pick up, then pick up both the sides. Only we have picked up who gave the no confidence motion. I am the chairman. Petition number 1 is the chairman of vice chairman, chairperson of the board.
Yes, Mr. Sharma.
Matter is urgent, my lord, but the respondent 7 unilaterally is diverting fund, my lord, government fund as well as municipal fund. That shouldn't be allowed.
Yes, Mr. Sharma. Response of respondent number 5.
My lord.
If it does not come, we'll have to ask his personal appearance. Let this respondent number 5 send all the scan copy of the entire case diary
Yes, the record is.
to you.
Yeah, that is in the office. It is there in the office, the record.
Is there?
It is there.
So we'll take it up at
Lordship-
2 o'clock. Let
Yeah.
us see that.
I'll
record.
raise.
At 2, we'll pass orders then.
My lord.
It can be disposed of also, my lord, because
I
that
don't
thing,
know. Well, he's asking for time. Let me see the records first.
But in fact, the same interim prayer was made in the earlier writ petition, which was filed in the month of January. In January, my lord, they could not get an interim order that the
but
next
now we
writ
can
petition.
actually tender
It
laws
is-
and other
We don't
other
know.
things. Electoral funds,
That
how
we
it is
don't
done
know.
now.
We can't predict what did not happen tomorrow will not happen today.
My lord. So, my lord, but my lord, if they are pressing for interim, then my lord, I'll have to place my case in matter of the second because I filed affidavit in matter of the
It's
second.
okay. We'll see at 2 o'clock.
Absolutely.
Without looking at the records, I'm not changing my mind. I'm not making a predetermined decision. Continue at 2.
Yes.
One report has come, my lord. Finally.
We will permit the SIT to continue to investigate the matter. We'll
No.
just keep it after 3 months. We are not keeping this instructions or status report on record because this leads to premature disclosure may not be what do you call, it may hamper the investigation. But
CID
we
is still
can tell you that
investigating.
we are satisfied that the investigation, they are doing it. But your girl is not being traced.
Yes, ma'am.
You can just inform me that your daughter was last. There was a location track at Delhi. But after that, the mobile is switched off. Therefore, there is no way to find out. And she has reached Delhi without any disclosure of the manner in how she has traveled. Her name is not there in the
Any of the travel.
in the flight, in the train, and in the ESTC. Name is not reflected. So how she traveled to Delhi is again. Because from Silchar, we won't say the period, but they have made a weekly surveillance. In 1 week, there is no travel.
One thing, Lordship, I once asked you to know, we have filed an additional affidavit. We have named 3 persons therein, suspecting that they are involved with the kidnapping of the daughter of the petitioner, Lordship. Whether they have interrogated those persons or not, is there anything in the?
Where is your affidavit?
No, in the petition itself, we have filed an additional FIR.
Additional FIR.
Additional FIR,
Page?
page number 45, Lordship.
Page number?
45.
Page 44.
45, Lordship.
45.
In exercise.
This is a statement you did not give to the police when they took your statement. The statement you are disclosing in this 5th July 2023
Yes, Lordship.
does not appear to be a statement before the police when they interrogated you, when they took your statement.
Lordship, actually, before filing the additional FIR, we have filed an FIR. In that FIR itself, we wanted to name these 3 persons. But the police officer in charge of the Silchar police station.
No. What prevented you from disclosing those names when the police interrogated you, when they took your statement? You did not say that.
This K. Omit Singh is the last known person who was in contact with the daughter of the petitioner.
No. His tracking is blocked by your daughter. His name is in the reject call list of your daughter.
Paragraph 8 and 9, 8 and 10.
Paragraph 10, they say that you have interrogated your husband,
Yes.
your husband was also interrogated.
8 and 10. And then they are also trying to recover that deleted data by officer.
Your daughter, the husband of your daughter was interrogated several times. Uh, Mr. A.D. Chaudhary and counsel for the petitioner, as well as Ms. M. Burman, and the government advocate appearing for the respondents. Next paragraph. By order dated 5/4/2024, the issue of maintainability of the litigation was kept open, which was reiterated by order dated 22/4/2024. Full stop. Next paragraph. However, from the status report of investigation which is produced by the learned government advocate, we find that this is a case where the daughter of the petitioner had gone missing, and the investigation still not complete. Therefore, the court is inclined to hold that the present petition will be maintainable. Next paragraph. As indicated above, the learned government advocate has produced status report of investigation sent by the Superintendent of Police, capital AHT, CID, Assam, which indicates that the persons named in the FIR and additional FIR filed by the petitioner were interrogated by the police. No information. No substantial clue could be unearthed. So, we were taught that the status report dated 17/4/2024 indicates that the CID of the state has taken various steps to obtain clue of the missing daughter of the petitioner. From the said note, it appears that the manner in which the matter is investigated cannot be said to be lacking in any manner. Therefore, the court is of the custodial opinion that the CID continue with the investigation. Next problem. The status report dated 17/4/2024 produced by the learned government advocate is returned as any premature disclosure thereof may hamper the investigation. Full stop. Therefore, this report is returned back just to enable the learned government advocate to produce it as and when again called for. Stop. The CID Assam shall give an updated status report on 24/6/2024. Almost 2 months you are getting, give an updated status report. This we are returning. Item 5.
Item 567.
And I have given one notification.
We should take up the matter.
Yes.
Problem is that the abolition was done in the year 2023 June. Almost.
No,
1
now
year.
he's engaged as he's nominated by name.
Yes.
So now we'll take up, we'll allow this petition.
My lord, I have another my lord prayer. Actually, one portion of my building was demolished, therefore other was unutilizable. So one of the prayer was there. More than 2 years passed prior to that. Kindly come to page number. There is a order by the previous arbitrator to joint survey the remaining portion. And that report is still not been given to me, although it has been already prepared and sent to the arbitrator. I have applied before the Golaghat to give that report. If my grievance is addressed, then I can demolish that portion. So Kala or PWD may be directed to give that report to me, because before the arbitrator there might take some time, my lord. So prior to that, if that report is given to me, my lord may kindly come to page number 16 is the relevant portion, 15 is the annexure 3. That is the order.
Yes.
11 portion is a page 16. Direction has been given for joint survey, my lord. The last paragraph. Third line. The ADC Kala Golaghat, manager NHIDCL, executive engineer PWD, circle officer Golaghat revenue circle are make a joint field verification of the remaining portion, and that is already done. And as per my instruction, the report has been given by the PWD to the Kala, and Kala has submitted before the arbitrator. But that report
still has not been reached to my hand.
No, once you go to the, once you go before the, this authority, they will give it to you. You make a prayer there.
My lord, if that,
Okay.
but time period may be given, my lord. Otherwise, my whole building is standing there, half demolished.
Okay. But Mr.
DK Nath.
You can ask the counsel for the petitioner. CGC is appearing. CGC will be appearing. Respond number 1. MOTH. MRTH, you'll be appearing.
I can appear.
Okay.
1 and 7.
After Karugal in it. Also, Mr. Arthur Karugal in it. Counsel for respond number 1 and 7. This is PR Mathur and it's standing for Revenue Department appearing for respond number 2. Mr. B. Govind and Mr. Chandrasekhar for respond number 3 and 6. And Mrs. M. Berman and the government advocate appearing for respond number 4 and 5. Next, by filing this petition under Article 226 of the Constitution of India, the petitioner petitioners have prayed for a direction upon the respondent authorities to direct the respondent number 1 to direct the special secretary to the government of Assam from arbitrator to dispose of the arbitration case number 25 of 2022 filed by the petitioner. It is posited that the land of the petitioner has been acquired, which on which his house was constructed, and that the zirats in respect of the construction was not assessed, for which the appeal for which arbitration was sought for in accordance with section 3 capital G within bracket 7 CG7 of the National Highways Act.
PG5, man.
Five. Next one. The learned counsel for respondent number 1 and 7. Mr. Bhattacharya, please be seated.
I for 2.
Okay. Standing counsel for respondent number 2 has produced a copy of communication number 1512/15/2023, by which the government has nominated Sri Ashok Kumar Barman, IAS within bracket retired, Special Secretary to the Government of Assam, Revenue and Disaster Management Department, for appointment as arbitrator for the state of Assam for settling the disputes in connection with the acquisition cases acquired under the National Highways Act of 1956. And the Government of India was requested for issuance of notification as per the provisions of National Highways Act of 1956. Notification has been issued.
Yes, notification has been issued.
Next one. Learned standing counsel for respondent 1 and 7 has produced a copy of Gazette of India Extraordinary published on 21/2/2024. The project that provide notification bearing S full stop O full stop 805 within bracket capital E bracket was dated 21/2/2024. The Special Secretary to the Government of Assam has been appointed as the
Arbitrator.
as the arbitrator
Arbitrator.
for the purpose of performing the duties of an arbitrator under the National Highways Act. Next paragraph. In the said notification, it is observed that the department held by the Special Secretary to the Government of Assam is not incorporated. However, the learned standing counsel for respondent number 1 and 7 submits that it would be the arbitrator would be the Special Secretary to the Government of Assam, Revenue and Disaster Management Department, as the concerned officer, namely Sri Ashok Kumar Barman, IAS, retired, has been nominated by name. And therefore, whatever department he holds, carry with him the power conferred by notification dated 21/2/2024. Next paragraph. Another grievance of the learned counsel for the petitioner is that the joint survey report has not been furnished to him, which is found mentioned in order dated 2/2/2023 in arbitration case number 25 of 2022. Next paragraph. In view of the notifications referred above, all the notifications referred above dated 15/12/2023 and 21/2/2024. This notification stands closed with direction to the petitioner to approve to appear before the nominated authority by producing a certified copy of this order and there is hope that the notified arbitrator shall make an attempt to dispose of the arbitration proceedings of arbitration case number 25 of 2022 within a time-bound period of 3 months. To stop. It is also provided that in the event the petitioner applies for copies of document forming part of the said proceedings, the same shall be punished to him on payment of requisite cost. The photocopies of the notification dated, sorry, order dated 15/12/2020 and notification dated 21/2/2022 is retained as a part of the record.
May I point out something? As per section 29A of the Arbitration Conciliation Act, the time limit is 12 months. 12 months.
12 months.
29A, my lord, as per statute, my lord. From the date of appearance by the arbitration.
But that arbitrator has already appeared.
Yes.
It
From
was
the
filed
start of
for
the, from the start of the period, as per the language.
29.
That's my kindly period for.
This case is of 22.
No, he's been nominated now. Earlier mandate would not be there. You know about the term de jure? What does it mean? De jure?
De jure and de facto, yes.
What does it mean?
As per law.
You must have jurisdiction. The
Correct.
time he was not notified cannot be a, it would be ab initio de jure, will not be authorized to do it. Shall we dispose of in a time-bound manner, keeping as prescribed under section 29A of the Arbitration and Conciliation Act of 1996. We should commence from on the date when the petitioner or his representative appears before the said authority.
Okay.
3 months will happen.
All three cases, same order will be.
6 and 7 same. Okay. Here. 6 and 7. Without difference of notice and respondents.
Item 8.
Yes.
My lord, here the petitioner an orphan is about now going to be 20. His father had occupied a land measuring about more or less two lessa, my lord, about 290 to 300 square feet area in ward number 12 of Lakshmi town, my lord. And there the 3 persons, father, mother, and the child were living. Parents died, and he is alone now. In these 3 lessa, 2
I'll
lessa.
tell you why we posed this question.
Mother?
In the morning, we posed a question. We'll tell you why. You come to paragraph 7 of the petition.
Yes.
The petitioner states that the petitioner approached the executive magistrate on so and so for allotment of land.
Yes.
Now, allotment of land cannot be done by them. It would be it would be an application, online application under Vasundhara scheme. That has not been done. So there is nothing on record to show that an application as authorized by law is made.
Annexer I, my lord, there I find, of course.
Page?
Page 31. Application so to who are them? These are also not, my lord, very.
Not a week.
No.
This is not a
The deputy commissioner, my lord. Tauzir revenue has been being paid by 2002-3.
No, that is okay.
And more than 15
If
years.
you are benevolent, you can pay the what you call that land revenue for XYZ.
No, it is in my name.
No,
father's name.
We are not on that. The issue is that if you want to apply and get a land allotted in your name, you must do it in a manner which is prescribed by law.
Yes. My lord, let me just check up.
you please get instructions because that is the reason we were.
No, my lord,
trying to dismiss
he's
this
a
petition.
2 days of that, he's a small pigeonhole type of rooms, but 2 rooms, they live and also a small shop there. 2 days of land only, 290 square feet. Nothing else.
No, whatever be, but if you want a land application, it can be done in that manner.
That formality matters this, but does not know. Or he has put application my lord to Deputy Commissioner of Lakhimpur. That was of course my lord in just this
Mr.
month.
Sharma,
Last
since
application.
you have appeared, we'll take it up day after tomorrow. We'll be.
What I am proposing, my lord, let him apply formally because he might
No,
not know.
but for that we can't issue.
Just the orphan of
But
19.
for that we can't issue a writ.
My lord?
For that we can't issue a writ. A writ cannot be issued for that purpose.
No, disposal in the sense, my lord, let him apply formally, my lord, and in the meantime, till that application considered.
No. That will be very difficult. Once an application is not there to pass an interim order, would be.
No,
taking a lot
application
of-
is there. Application is there this month only. Last application that is. Otherwise, order 2019, my lord, land policy, a landless person can be settled up to 1.5 katta of land. Here is on consent to less of land where he is taking his livelihood also and living there also.
But that's okay. You're not
How much
saying.
it will be, my lord? Two less of land will be this much.
No, whatever we understand it's 144 square feet is 1 lacha.
Yes. Two less
It may
of
be- it may be
280.
anything, but the question is that it must be applied in a manner prescribed.
The online system has come now, my lord. How to get this way? People know, native people.
You have to apply, my lord, in Bosundara scheme, my lord. After that, my lord, the document verification is there and field verification is there. You have to apply in proper manner, my lord. Not just like this application, my lord.
ये routine application through Dr. Bikhaye, my lord, circle revenue officer, and that generally that is done in the village, that is forwarded to the deputy commissioner with an affidavit. That is landless.
No, those things are now matter of past. Personal scheme, the application is made, it will be done in that manner only.
My lord?
You see, now there is a scheme which is in force.
Yes.
We can't say that it should not be followed.
But that can be followed, my lord, unless these people are trained or they know it. They give the poorest of the poor family living in 2 acres of land, my lord, in this present age, can we imagine, my lord, such a situation in Assam still existing?
Very difficult, Mr.
My lord,
Mr. Have you seen the notice? Page 35.
yes,
Assamese version is at page 36.
yes,
It says that from that notice, it appears that your shop is on a road.
Yes.
If it is on a road, you can't get the allotment. Land cannot be allotted to you if it is on road. The place is on the way of Namghar and State Transport Corporation factory. So
yes.
therefore, the shop is in the road. You can't get an allotment there. So therefore,
Let them,
question
my
of-
lord, give. Then, my lord, it is up to the deputy commissioner, the
No,
government
but
to
you are asking for
consider
interim. So we are telling you that
to set
interim
me
is
somewhere, my lord.
interim is not permissible in
For the
such
last
matters.
30 years that was running there. Even the document of 2002, 2003 shows.
So that may be okay, but the question is that this hikers is not appropriate. We can't give a stay there.
Let them give some alternative of equal strength to to the extent of the allowed by the land policy. Anywhere where I can live and make my livelihood. A man cannot be from an indigenous man cannot from the state man just everything from two less of land. This much of land.
It's not a question of two lessons. It's a question of place where you are asking for two lessons.
My lord?
It's not a question of two lessons. It's a question of place where you are asking two lessons. It can't be on a road.
Cannot be on road, my lord, but they lived in for 30 years. What to do? At the time, there is no will of the land.
We don't have, you see, we don't have documents to show where is the land situated. Is the map itself is not
Even
there.
trusting this, my lord, the notice, it is on the roadside. It's not pigeonhole shop, my lord, running the livelihood of
It's
the boy.
okay. Still we can't. Heard. Mr. R.P. Sharma, Senior Counsel.
Let them give somewhere to.
We just permit you to apply, nothing
Hello?
more. And you respond to their show cause notice.
Yes.
Assisted by Mr. R. Dattar and counsel for the petition.
Lots of my lord, even payment dollars are allowed some alternatives. Please to stay, my lord. Those are the days, my lord. Now they people condition is same, my lord. They might have passed, my lord. We have not changed. We are same. Your lordship, what are your lordship during the bar and now is same. The mentality we have got same. The living style is same, my lord.
No, but there is only one difference.
Yes.
There is only one difference. Now
Yes.
we are bound by law. When we were there, we were not bound by law.
My lord, no. Law is for human beings. Law is for human beings. So some tinge of humanity and sympathy must be there in law. Other laws will become wild.
But there's things which are not permitted. Also had Mrs. P.R. Counsel on it. Standing also for the revenue department appearing for respond number 1. And Mrs. M. Burma, the government advocate appearing for respond number 2, 3, 4 also. Chairman, you can appear. No. Oh, okay. 5 and 6. 4 now. Circle officer.
Circle officer and the circle officer and the district commissioner. I can, but we have to mention the circle officer. Circle is not named in the kind of picture. So for sending.
Oh, it's okay. It will only be that that area. What do you call? Not Lakhimpur.
Not Lakhimpur. Notice by the municipal board, my lord, not by the date.
No, she's pointing out that the cost is defective.
Circle.
Respond number 6. Circle officer of which area? Respond number 6. You have not given there. She's only pointing out a defect. Circle officer where? Respond number 6.
Lakhimpur, my. This is Lakhimpur only. Lakhimpur.
Respond number 6. Next para. the President, Municipal Board, North Lakhimpur. Has issued a notice to the petitioner to vacate vacate and remove the shop from the premises, from the place mentioned in the said notice within a period of 3 days. During which the petitioner was informed that the action would be taken under the Assam Municipal Act from 1956. Said order is settled in this petition filed under Article 226 of the Constitution of India. Next part. The learned senior counsel for the petitioner has submitted that the petitioner is occupying the said land measuring about 400 square feet since last 33 years.
Well, it won't, about 300 square feet, nothing.
No.
Less.
In your document, you are saying 432 equivalent to 400 square feet. Some document somewhere.
But in paragraph 2, my lord, I've given the
No.
2 lesser. And in application also. Anyway.
No.
Anyway, no, that was the option.
If I have read it somewhere, it has to be. In one of the documents, you are saying 432 square feet equivalent to 400 square feet.
There was one point more, my legal point. Here also just note my submission also.
Yes, page 37. You see there are two description given there, 432 square feet and 400 square feet. Correct.
Anyway,
400 square feet.
300 or 400.
And on the death of his father, he has been paying the requisite land revenue and the municipal taxes. And the land is covered by Tozi Patta number 41.
The numbers,
Guard number
625.
625. On the part 4 of Lakhimpur Buzar. Full stop. It is also projected that when arrived, the father of the petitioner had applied for the district magistrate Lakhimpur not to evict the applicant. And it is also projected that on 14/3/2023, the petitioner had applied for granting a patta of the land in his name. Next part. Under the present scheme in force for allotment of land, the government of Assam has notified the Basundhara scheme, and applications for allotment of land is required to be made through the said scheme and portal. Full stop. Next part, therefore, comma. The petitioner is at liberty to make an appropriate application in the manner prescribed for allotment of land or for granting of patta in respect of the land on which is currently occupying in the manner prescribed, which is through the Basundhara scheme of the government of Assam. Next paragraph.
One
The
submission.
senior government, the senior
My
counsel
lord,
for the
one submission just to note. This is the government land, my lord, admittedly. And the municipal, it is not the land belonging to municipal authority. The notice is issued by the municipal authority. That submission will noted.
Okay. The land senior counsel for the petitioner also submit that the land does not belong to the municipal authorities, yet the municipal authorities are issuing the notice imputing this writ petition. Posted. It is also submitted that unless the notice is interfered with, is every likelihood of the house being demolished and the petitioner being evicted from the said land. Next part, be that as it may. Insofar as the eviction notice dated 14/3/2023 by the, sorry, the eviction notice dated 3/4/2024 is concerned. It is at which page?
Is the 35 English translation, my lord.
35. Numbers, page 35. Page 420 is concerned, comma, the court is inclined to grant 7 days time from today to the petitioner to respond to the said notice dated 8/4/2024. And the President, North Lakhimpur Municipal Board shall give an opportunity to the petitioner of being heard. And thereafter pass appropriate orders in connection with the notice dated 8/4/2024. With the aforesaid observation and liberty granted, the question stands closed.
Kill them, my lord.
No, I'm not saying it. We are giving you 7 days time.
One more thing, anyway, that I'll reply. Because he has said that the stop is only illegal without license. As I've annexed. How do you?
Dispose. We're closing it. 41/42.
Item 41 with 42.
Can it be 10 days, my lord? Because we have to send by post or by courier. Courier is not possible, by post.
Downloaded copy, we say.
Up to
Downloaded copy.
my lord?
Downloaded copy, you can download there and take it.
No, we can, certificate copy will get 2 3 into 2 days. Tomorrow at
Oh,
10 days, my lord. Instead of 7 days, 3 days will not.
Okay,
Nothing,
10 days. 10 days.
10 days. That's what you also wanted to see the record. My lord.
Let us see that record. Ms. Sharma, you got the record?
Yes.
You can-
The proceeding.
No, not this proceeding book. This proceeding book is not the record we wanted to see. We wanted to see the record pertaining to the manner in which the some people picked up before the meeting.
Yes.
Lordship grants me 4 or 5 days time.
Okay.
My lord, affidavit has been filed by the DC, my lord.
The affidavit, my lord, they say that they picked them up.
Yes. They admit, my lord.
Page 63.
Correct. So we wanted the record of the, not of this record, but the police case where police case where
Police
they have
diary.
been picked up.
Police diary.
The case diary. I will ask.
I'm saying police records, whatever they have. It may be entered in the police diary, may not be entered
My
in the
lord,
police diary.
that record may be, that
It
register
may
will
not be
be
entered in the
ATM, my
case
lord.
diary, we don't know.
No.
So we are asking for the police record,
Entire case record.
police records along with the case diary.
Yes. Lordship may oblige.
You're giving them time then.
My lord, the proceeding they have given to me copy is whitener is used, signature is missing, and even non-members are allowed to participate in the meeting. That will argue in the. And this is.
Proceeding on which date?
My lord,
Proceeding
on
on which date?
5/1 2024.
5/1
2024.
24.
Yes.
Flag mark.
5/1 24 does not have any erasing.
I don't know, my lord, all these things.
But
Yes, flag mark, my
who are the members
Orange
present, my lord?
color, flag mark.
There are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 people.
Who is 3, my lord?
Huh?
Who is 3? Here we are giving blank. The person given. Whether there is
it's
improved
filled up.
letter or what?
Here it is filled up.
That
You
was in
can see it.
Assamese, it is in English.
Show it to
No, English or whatever it is.
You see it.
So, yes. It is, my lord, the very use of the inks indicates, my lord. These 2 persons are missing in our with the yes, it was in English, my
I don't
lord.
know, whenever
No,
I propose to
done.
do
You
anything-
lot to kindly come to. You lot to kindly
No, no, I
come
tell
to.
you, Mr. Sharma,
Yes.
please, 2 minutes. Whenever I propose to do something,
Yes.
I take stock of what I do. You see, it may happen that I have signed, say there's an order of 5 pages, I signed 5 pages. Then it occurs when the orders are rechecked by my secretary before uploading, they find that maybe there is some typographical error. So what they will do is that this, supposing page 4 has an error, they will just print out page 4 and give it to me. And whatever pen I have in my
That is
table,
different thing. But
I will
here
sign
now,
with that.
that is different thing. That is
So
totally
therefore,
different. What is there?
In one order, you may find 2
Same day,
signatures.
same time. You also can see. 1, 2. 6, 7, 8, 9, 10. 10. Same. And my lord, this is number 3 given to us in English. How it has become SMS in this proceeding book?
Who was English?
Divine intervention. You have seen the goal of Maradona, hand of God.
We are given the photocopy, they have got them. Others are all right. 2, 3 persons are missing from
Which
this
page?
photocopy. Yes, my lord. Actually, you'll also kindly go to their affidavit in opposition in item 42. Item 42. Oh. Yes, item 42.
Definitely on page
Page, my lord, 54.
64.
54.
54.
And some are non-members are allowed to participate. This number 3 is also not member of the board.
54, yes.
Yes. Number 3.
54 is annexure 1.
Yes.
This is not the proceeding book.
Yes.
This is a letter to Deputy Commissioner.
54 of their affidavit in item number 42 in WPC number 168 of 2024.
Fifty-four minutes of meeting. Oh, maybe page number. This is page 1661 here. Now, what you're saying, number 2?
Number 3, my lord.
Number 3, there also is Assamese.
It is in SMS, my lord. I have also, it's SMS in my record. Also.
But in the copy given to them by them is G3 away. Let me argue or let the government advocate for speaking.
Okay.
He is not
And
member also.
where is that
It is not
document?
Pego, my lord. We showed
No. What is the document where it says that the people were picked up for law and order? Where is that?
Page 63 of the counter affidavit filed by the
Deputy Commissioner.
District Commissioner in 168 of 24, item 42, madam.
Yes.
63.
Page 63. The report was called for by the DC and this is the response of the
No, page numbers are different then.
page 63, madam.
63.
No. Page numbers are different.
In item 42, madam.
883 letter. That is in
Yes,
in the code book, it is page 70.
I'm awfully sorry.
It's okay.
You have put them in the midst of the meeting. Just meeting has started. Then these two persons were picked up. The vice chairman, she had no case at all. Another one was said to be there is a case, and they got the time to be arrested during the date. They could wait on the door of the board's office to allow the meeting to complete, and while coming they could have arrested the person is picked up. It's very planned, and all at the instance of the respondent 7. He is a very powerful, powerful person anyway.
Yes. In this, Mr. Biswas, what do you have to say?
My lord will kindly, if I need to respond to them, my lord, since my lord will kindly come to the FIR which they have lost. Your lordship is holding the brief of item 42 or 41. I will indicate page number.
Both.
If your lordship sees item 42,
Read petition number.
168.
Yes.
Kindly, your lordship will come to the FIR they have lost, page number 25.
You are picked up from the bazaar while going to office.
Yes.
My lord will see the FIR which was lost. It is a document which is contemporaneous in time. Here there's an unknown person. In read petition, they come and straight away alleges me. My lord, they are mixing up 4 issues in one read petition. My lord, their basic grievance is that they have called for a no confidence motion, and the and on the date when the no confidence motion was fixed to be held, on that date they were stopped by the police. So their prayer is also, my lord, in 168, lordship will see their prayer.
I've seen that.
My lord, my very case is that the very process of initiating a no confidence motion against the chairman in the instant case is dehors the mandate of the Assam Municipal Act. Because, my lord, in a no confidence motion, my lord, the deputy commissioner has got no role. The requisitions are made to the deputy commissioner, not to the chairman. In a no confidence motion, to whatever little I could lay my hands on, my lord, the requisition will go to the chairman. If the chairman fails to call the meeting within 20 days, then the person who has signed the requisition will call the.
Mr. Vishwas, we are hearing a writ petition of Mr. Sharma.
My lord.
The legality of the meeting is not under challenge.
My lord.
So we are not hearing a counterclaim.
My lord.
So if you have, if that no confidence motion is allowed to proceed without any demur,
my lord,
this will be a very, what do you call, wrong place to argue that.
Now,
whether it is right or wrong,
my lord,
is nobody's challenge.
My lord, in fact, we challenge the no confidence motion, my lord. We challenge this no confidence motion. However, my lord, in the meantime, since that date has lapsed, my lord, therefore we have to withdraw that writ petition, my lord. But, my lord, be that as it may, my lord, on the next date, because I have filed a detailed affidavit, my lord, these are all new things which they have come up in their writ petition. Their document says something else, their writ petition averment says something else. In FIR, they say some unknown person, in writ petition, they say.
One person was unknown, but picking up 2% from the meeting hall is different.
Let him complete.
What is saying?
So,
let him complete.
So, my lord,
tried not to.
And and the no confidence motion was eventually called by the deputy commissioner.
Not called, my lord. Wrong statement.
My lord, I have annexures there, my lord. My lord, since the senior have said, I'll indicate the page number. My lord, will kindly come to page number 24 of 168. There was at the behest of the vice chairman, but page number 23. 24. 23 is vice chairman, 24 is deputy commissioner, district commissioner. And the person who they are saying is an alien to this meeting is in fact a representative of the deputy commissioner. Section 43, my lord will see.
Which page you said was the notice?
Page number 24.
Yes.
And the requisition was made to the deputy commissioner at page number 19, my lord will see.
Page?
Page 19.
Yes.
Now, my lord will see the language of page 19, my lord. Letter of no confidence motion against the chairman, that is the subject. Now, my lord will kindly see the last para. What is their prayer before? In the light of the above, we earnestly request your intervention to terminate. Mrs. Lavino Pite Dole and appoint a new chairman. through democratic procedure with full concern of the board and take appropriate measure as we, the board members, collectively bring the no confidence motion in 2/3 majority. Now, my lord, this is.
Yes.
Now, my lord, thereafter, the deputy commissioner sends an email at page number 22. My lord, is there at page?
Yeah, just now.
Right.
What is the date I can read?
The date here is
Page 19?
bottom right hand side, 12, 12,
19?
2023.
No, page 19.
19. Now, my lord, here they have tampered with the date because in the other writ petition, the date is clear. It is 01/12/2023.
01. There is no tempering. Why
Yes.
should I temper?
No, no, I can.
What language you are using?
My lord, I am not saying, but there is a temperament. I can show, my lord, if your lordship juxtaposes page 19 with the other writ petition, it will be ex facie
Where is
clear.
that? Show us.
My lord, will kindly see. This
is
page number 25 of the other writ petition. My lord will see how distinct the date is. Page 25 of the other writ petition, that is 1526.
Yes. One.
Right hand side, your lordship will see the manner in which it was. Who has done it, my lord? I am not making any allegation, but this is what it appears to my eyes, my lord. And moreover, there is a received copy, there is no received copy. My lord, be that as it may, my lord. So I take it as 1/12/2023.
Yes.
Now, my lord, then on page 22, on 12th, the deputy commissioner gives me 15 days time to call for a meeting, a board meeting, as per the provision of the Assam Municipal Act. Thereafter, my lord, the vice chairman calls the no confidence motion with a copy to the deputy commissioner at page number 23.
Yes. In the act, where is the power of deputy
Yes.
commissioner?
My lord, in the act, my lord, will kindly come to pay section 28(2).
22 is the board.
28
28 is the board.
is the board, your lord. Now, my lord, it says, my lord, an elected chairman or vice chairman may be removed from his office by resolution of a board in favor of which not less than half of the whole number
There
of
is an
commissioners.
amendment,
It is amended, it is now more than.
More than half.
More than half of the whole number of commissioners shall have given their votes at a meeting specially conveyed for the purpose. Now, specially conveyed means special meeting, page number 43 for a while, my lord.
Page number 43.
No,
Section
section
43.
43, the book
Yes.
which I am holding, page number 28.
Mhm.
Ordinary and special meeting, I skip subsection 1, subsection 2, my lord. The chairman or in his absence, the vice chairman may call a special meeting whenever he thinks fit and shall call one on a requisition by not less than 3 of the commissioner. No power to the deputy commissioner. The chairman and in his absence, the vice chairman. Now, if neither of them calls, the situation is scattered by subsection 3. If the chairman or the vice chairman fails to call special meeting to meet within 20 days, after any such requisition has been made, the meeting may be called by the person who signed the requisition. Now, my lord, the power of the deputy commissioner I could trace only in section 297 of the Municipal Act. That is during emergency. That is also for, my lord, for the limited purpose of safety of the people, my lord. This section 297, subsection 3. Power of state government in case of default and of deputy commissioner in case of emergency. My lord, may I read subsection 3?
Not.
My lord.
My lord, my lord, I'm just taking it for
Yes.
1 minute.
Yes.
Now, my lord, probably, my lord, what they are confused with is section 28, subsection 3. Section 28, subsection 3 gives an power to the state government to remove a commissioner. But state government cannot be represented by the deputy commissioner. It has to be by the commissioner of the department. Their letter, which they say that is a letter calling for a no confidence motion, in fact, though it is titled as letter of no confidence motion, but it reads it to terminate and appoint somebody else. Termination power the deputy commissioner does not have. It is a state government, section 28, subsection 3, my lord. So that being the fact, my lord, this is how the no confidence motion is initiated, my lord. Now, my lord, our contention was, if a valid requisition was made to us, us means, my lord, the chairman, you would have definitely called it within 20 days. The act provides, my lord. My lord, your lordship is aware, my lord, if an act provides a thing to be done in a particular manner, my lord, it has to be done in that manner or not at all, my lord. The deputy commissioner, they gives it to the deputy commissioner. He gives me 15 days time, my lord. And then he fixed a date. And on that day, they could not. This is the second part of the story. On that day, they could not turn up. Now, they could not turn up in their FIR. There is no allegation against me. The contemporaneous document does not say anything against me. It's very easy to, my lord, to indulge into mudslinging by saying political vendetta, all this, my lord, but there has to be some material to that. If that be so, then at the relevant point of time when they've lodged an FIR, why did not they mention the name of the chairman or the person whom they are now they are introducing after 4 months of the state meeting, my lord? And the prayer is also, my lord, in both the read petition, the prayers are also, my lord, to whatever little I understand, my lord, this is a misjoinder of cause of action. In the second read petition, they have assailed the minutes of the meeting as well as one notice inviting tender. One notice inviting tender and the minutes of the meeting of 5/1, January, 5th of January, is being put to challenge in the second read petition. And in the first read petition, they're seeking some protection. In fact, my lord, the second read petition was filed only when on the last occasion, the court indicated that in the absence of any such challenge, the court cannot interfere. Otherwise, my lord, the second read petition was filed at a very belated stage.
Okay.
My lord, that's why I pray for some few days time. I'll also just reply to this, or else I have already replied to WBC 168. This one, my lord, after acceptance of notice, this has come for the first time, my lord. Just take few days time, my lord. I'll file a reply, my lord. May take it up for disposal any date convenience to your lordship, my lord.
What is the prayer in 1526?
1526. They pray for this NIT stay of the proceeding of that minutes of the meeting and the NIT. My lord, this NIT, I have instruction that already work order have been issued. Work is going on.
Where is that NIT?
NIT, they have annexed at page number 42.
Except J.
15th February.
Yes, Mr. Sharma.
Now I have to reply to what he has argued.
In the second iteration is wanting some time.
Anyway, that I will also consider. First, because he has already argued on the first iteration. Now I will also kindly come to page number 19. First iteration, there is 168.
Page number 19.
Yes, he has said that it has got, this notice has no confidence, no competence, and it is alleged to be under subsection 3 of section 28. First subject is no confidence motion against the chairperson. And last is there, my lord. What the last prayer is what? In the light of the above, we earnestly request your intervention to terminate Mrs. Lavanya Datta Dole, chairperson, and appoint chairperson, chairperson through democratic procedure with full concern of the board. And take appropriate measures as we, the board members, collectively bring the no confidence motion. How he has forgot?
What is the name of the chairman?
Madam?
What is the name of the chairman?
Lavanya Dole.
Lavanya Pait.
Pait Dole. Anyway, after marriage, she is become Dole. Now let's kindly come to page.
Just a moment. What is the name again?
Lavanya Pait Dole. She was Lavanya Pait. Later she married is Dole in the same community, and now she is Dole.
Vice chairman is?
Vice Sir Mr. Dev. Nine members out of 12.
Yes.
Now, my lord, will come to annexure B, page 21.
This President Lavanya Paik.
Paik, yes.
She's not the lead petitioner.
No, miss. She's not the petitioner. She's the respondent.
Respondent number 7.
7.
Yes.
Now we'll also kindly come to page 21. Because he is telling that the date of no confidence notice is tempered. Same date is here also, it page 21, annexure B, reminder to Deputy Commissioner, speedy inquiry and action regarding no confidence motion. So, this DC office PA receives it. We remind the DC Deputy Commissioner. Then you also kindly come to page number 22, which Mr. Land Council on the other side has not read in full, my lord, what the DC has done. He has not called the meeting. He simply forwarded it is addressed to the chairperson, my lord. Lavanya Pajdal is the chairperson. Silapatha Municipal Board, forwarding of petition submitted by the ward commissioners.
Just
With
a
reference-
moment,
my lord?
just a moment.
Yes. Page 22, my lord. Has it also got?
Yes,
May I read, my lord?
yes.
Yes. The DC addresses this letter through email, my lord, to the chairperson, Silapatha Municipal Board, forwarding of petition submitted by the ward commissioners. He forwards the notice which was given to deputy commissioner to it, because in section 20, lordship can see there is no mention who the letter should be addressed, unlike Panchayat Act in section 15. In Panchayat Act, the letter should be addressed to the secretary and he will put up to the president of the Panchayat. But here there is no provision on section 28 who to address to it. It was passed in 19.
What has happened in that resolution? In the meeting, what happened?
I'm coming. Just let me bear me, my lord, for 5 minutes. With reference to the subject cited above, please find enclosed here with a copy of the joint petition dated 1/12/2023. This date is all right, 1/12/2023, there is no tampering. Submitted by the vice chairperson and other ward commissioners, Silapatha Municipal Board, on no confirmation motion against the chairperson. In this regard, you are to convene a board meeting as per the provisions of the Assam Municipal Act 1956 as amended within 15 days from the receipt of the letter. Copy of the minutes proceeding of the meeting to be submitted to the service. This is for kind information section. This is 12/12/2022. He simply forwards it. He didn't direct. To request you, as per the provisions of Municipal Act, legally you do it. There is no compulsion on put on the by the deputy commissioner on the chairperson to convene. Then, my lord, 15 days having elapsed. 15 days having elapsed, my lord.
Yes.
The 15 days having elapsed, my lord, the vice chairperson, since the chairperson has failed to either acknowledge or to convene the meeting, is required to convene. Then the vice chairman, my lord, by virtue of section 43, subsection 2 and 3, convenes the meeting. With reference to the subject cited above, under reference, the undersigned would like to bring to your kind honor, as a lordship, my lord, page number 23, annexure D. A kind notice that the present chairperson, Srimati Lavanya Dole of Silvas Municipal Board,
No,
made
that's okay. You
the-
did not read these contents. We understand.
Yes. So she
It's a
calls the
notice,
meeting. And copies be also given to the all ward commissioner, including the chairperson also, executive officer, DC, MLA, MPs, because by virtue of their office. And the date was fixed by the vice chairman 5/1/2024 at 2:30 PM. You'll also kindly note the date. They were picked up at 3. The police picked up 2% from at 3.
Yes.
Now, my lord, because this is the controlling authority for the government. Or where there is subdivision control authority, I have so to a lawsuits from the Municipal Act. This is Deputed Mr. Biswajit Pukan, ACS District Development Commissioner, Dhemaji. In Municipal, in Panchayat Act also same thing is done. One government representative is put to oversee the proceedings. In pursuant to letter received from the Vice Chairperson, Sheila Pathar, by notice of so and so, 29th of 2024, regarding convening of section board meeting under provision of section 28 of the Assam Municipal Act 1953, in view of no confirmation motion against the chairperson, Sheila Pathar Municipal Board, Sri Biswajit Phukan, ACS, District Development Commissioner, Dhemaji is hereby nominated as representative of the District Commissioner Dhemaji to attend the meeting to be held at Sheila Pathar Municipal Board office on 5/1/2024 at 2:30 p.m. The person deputed. Now, while first lawsuit come thereafter, I take a lawsuit to section 47 perhaps. Yes, 47 mallet of the Municipal Act. How the DCR SDO comes in. Has the lawsuit got some mallet? 47. May I read mallet?
Yes.
Minutes of the proceeding. Minutes of the proceeding of all meetings of the board shall be entered in a book to be kept for the purpose and shall be signed by the president of the meeting and shall be published in such manner as may be prescribed and shall at all reasonable times and without charge be open to the inspection of the taxpayers. A copy of the minutes of the proceedings, say of all meetings of the board shall forthwith be forwarded to the board by the board to the deputy commissioner and the division, and another copy submitted to the state government. The minutes shall also be laid before the next meeting of the board for confirmation. Shall also be signed at such meeting by the president if the same has been correctly entered. So, my lord, this meeting, if any held, shall not be put in execution until the next board approves it. This is always the procedure. Last meeting approved and then it comes to execution. So, so deputy commissioner, civilizations power, state government power is what every proceeding of the board meeting, whatever the proceeding, a general meeting, special meeting, or audit meeting are to be dispatched to the deputy commissioner. Then lordship will kindly come to yes, miss section 296, my lord. He did 297 only. 297 is for special emergency purposes. General power of control is if to suspend the board meeting, proceeding is under 296 of Assam Municipal Act. 296 one.
Yes.
The state government, the deputy commissioner of division, the commissioner of division, the deputy commissioner, the director of municipal administration, the additional chief deputy commissioner or sub-division officer in charge of the sub-division may by order in writing suspend the execution of any resolution or order of the board or prohibit the doing of any act which is about to be done or is being done in pursuance of a or under the cover of this act or in pursuant to any of the sanction or permission granted by the board in the exercise of the powers under this act. If in its or his opinion, the resolution, order or act militates against the fundamental rights conferred by Part 3 of the Constitution of India and the state policy of the directive principles laid on Part 4 of the Constitution of India is in excess of the powers conferred by law, or the execution of the resolution or order or doing the act is likely to be likely to lead to a serious breach of peace or to cause serious injury or annoyance to public or to hurt any class or opposition. When the deputy commissioner, so administration, sub-division officer in charge of subdivision makes any order under this section, he shall forthwith forward a copy thereof with statement with reason for making it to the state government, which may thereupon rescind the order or direct that it continues in force with or without notification permanently added. So this is power is there to even suspend, rescind, revoke order. If it is in breach of some law or some fundamental rights or manner, if it brings causes breach of peace. So he says no, there is no power that he is. He is the supervising authority in all cases, even in Municipal Act or Panchayat Act. Because there is no specific provision under section 28 to give the notice to chairman. It is I've been doing one. We've been doing your lordship might have done number of municipal cases of no convenience under 1956 Act. We have never heard that. In general, it is the deputy commissioner is the controlling authority, and he forwards it. He does not convene the meeting himself. Since the motion was against the chairman, and chairman failed to convene the meeting, she was giving requested by the deputy commissioner by forwarding the notice. Now, my lord, this page 24. I have already told you also, my lord. The Bishop Phukan was nominated as the representative of the deputy commissioner to attend the meeting, to oversee the meeting. Then come to page 25. These are not denied. These FIR and other things are not denied by the SP, by the deputy commissioner. It's the report of the SP, which is annexed in his counter. 5/1/2024. The date fixed for no confirmation motion. With due respect, I beg to inform that today at around 3 p.m. some unknown person, that is first person, there are 3 persons kidnapped. Persons kidnapped my son Sri Jitendra Kutum from near Silapathar Municipality Board office in front of daylight, since my son is untraceable. I therefore request you to please kindly in front of the municipal office while he was going to attend the meeting. This Jitan was kidnapped by someone. Then was second FIR on to the SP Malar on 6/1/2024 by the Vice Chairman herself. Page 26. These are not denied. With due respect and humble submission, I am to inform that on 5/1/2024 around 3 p.m. near Silapathar Municipal Board office, when I went to my office for a special board meeting under section 28 of Assam Municipal Act, the above said police personnel forcefully dragged me in the road without any reason. When I refused to sit in the police vehicle, they said officer physically tortured me and treated me like a criminal and took me to the police station. I felt both physically and mentally traumatized by this act of action taken by the police personnel on me. We have learned that police officer mentioned above was only preventing me and my other ward commissioners from attending the crucial board meeting. The said police officer not only prevented me from attending the meeting, but also violated my fundamental rights. I therefore kindly request you to take immediate action against the above said police personnel. This is not denied. Then, my lord, on 6/1/2024 itself, page 27. Eight ward commissioners put in application to the district commissioner. No action is taken. Not denied. Take action against the preventing the persons attending the meeting, creating chaos during the board meeting, and not allowing them to take final decision. This is that. Now I will kindly take our lordships to the affidavit filed by the respondent number 7 to 10. 7 to 10, my lord.
Yes,
Here's the last good, my lord.
yes.
Well, also kindly come to page 38 in paragraph 2, it is sub paragraph, my lord. Because there seems to be dearth of English figure, man, English numericals. So it is in a Roman sub paragraph. Sub paragraph 4, my lord, page 37 onwards, you'll also kindly see.
Please,
This I will dealt with.
please remark those pages. In the court copy, the affidavit starts from page 41.
Yes.
Your numbers will have to be remarked.
No, my lord, first there is statement, huh?
Page number.
Yes, number.
It's okay, I'm getting it, but please remark your pages. It will be from, the affidavit starts from
No, no,
page
not affidavit. Affidavit starts from
41. The court copy, the page is 41, not what you have said.
Here
Okay,
in,
let us make
it is
that,
in my basement mark, it was 34.
No, it's okay.
41,
Just we are telling you it's 41.
43, then
No, it's okay, don't do it. You carry on with your pages.
paragraph, my lord, will come to paragraph, sub paragraph 5.
Yes.
That thereafter, in a most arbitrary manner, the vice chairman, the Shalva Municipal Corporation, it is not Procedural Municipal Board, my lord. Data so was received on so by the deponent and had called for a special meeting to discuss about the removal of the. So the chairperson admits that she received the notice dated 29.
As per the act, what is the time for giving notice?
20
What is the
days.
notice period?
20 days to the chairman.
20 days. So, which provision?
43.
Section 43, subsection
2 and 3.
I'll give the specific subsection, my lords. It is subsection
Subsection 3, my lord.
3, subsection 3.
43(3).
3.
Yes.
Yes.
Now I'll also kindly come to page.
And also please tell me,
I think it is
any of
47.
you, if the motion fails, when can the second motion be brought in?
No, there is no bar, my
There is no bar.
lord.
Okay.
That's what I was going to submit. There is no bar, unlike Panchayat Act, there is 6 months. Now I'll also kindly come to, I think it is page number, your lord's would be page number 47.
No, it's okay. Whatever page you say. Okay.
Sub paragraph 7, Roman 7.
Yes.
They are approbating and reprobating. Blowing hot and cold in the same breath. There the deponent wants.
Mr. Sharma.
Yes.
When it comes to interpretation of CPC, then it's well laid, and even I have authored a judgment where I have said that taking of contradictory stand in a written statement is permissible.
But Scottish law.
It is not permissible in a plaint,
No,
but it is permissible in a written statement.
Yes.
I am also author of one of such judgment.
No, that is true, mother. What I want to, first this this scheme of or this principle of appropriate approval settled by Scottish law, and it was followed by Supreme Court in 1956 Supreme Court. And once you approve it, you can reprobate it. So, mother, here what happened? You will also kindly see. They say the notice given by us on 1/12/2023 was illegal and without jurisdiction and not in consonance with section 28 of the Municipal Act. Well, accepted. Now I'll also kindly see. That deponent wants to approach this court by filing of a writ petition challenging the letter dated 1/12/2023 by which the Deputy Commissioner Dhemaji directed the chairman to convene the meeting of for considering the no confidence motion brought against the deponent. Very important paragraph. There are lots of here. The writ petition was registered as WPC number 76 of 2024. However, the same was withdrawn on 10/1/2024. As in the meantime, that no confidence motion meeting was already held. Held means the proceeding they were next, which I say to be temporary and manufactured later on after we are dragged out by the police. So once you say that notice was illegal, and you also approach this court telling that and say that that notice was illegal, so it should not be allowed to be passed through. But against that very notice, you hold a meeting, that so-called no confidence motion meeting, and say we have withdrawn the petition because that is held. Can they be allowed, man? So that means they accept the notice was legal, and at least they have said before the scope by withdrawing the petition. We accept the notice to be illegal. Now, my lord, they have announced that my lord, that proceeding of no confidence, my lord. Here in the, I don't know who are the, it is not very legible. No, these are the, whether these are one, two, four. For number one is MP, he is well member, except is a member of the board minor by virtue of the constitutional provision. ML is also a member by virtue of the, and they have the right to discuss and to vote. Rintu Pallab Barua, CEO, he has got no right to vote. Lavanya Pai, 10%, she has the right to vote. Babul Chakraborty, president, cannot vote because they say they have immediately elected Babul Chakraborty under subsection 3 of the.
You're reading where?
Malad, page 52 is Malad, I think it is some.
It's okay, I'll get it.
Number 1 and 2, well, they are members, being MP and MLS. Number 3 is the Deputy Commissioner nominee. It seems now it is clear. So he cannot vote. Rintu Pallab Barua is CEO, executive officer, he cannot vote. And Babul Chakraborty, president of the meeting, he cannot vote. Rita Das, you know. Rita Das is ward member. Monroe Das is ward member. He has his membership is under challenge because he has produced a duplicate birth certificate. 9 and 10 nominated by the government. They have got no right to vote on section 11 of the Municipal Act 1956. So how many are there? 1, 2, 3, 4, 5, 6. 6 members only. 6 members cannot pass the resolution. President, he cannot vote. So, my lord, this proceedings
This
are illegal.
7, 8, 9, 10 cannot vote.
7.
7 can vote.
9 and 10.
9 and 10 and 8 also, my lord, since his very membership is under challenge, being having submitted duplicate birth certificate. So, my lord, there in fact there are 6. At least there must be out of 14, my lord, more than half. There should be 8. So anyone, since you also wanted to call the diary, yes, diary from the police, definitely called, and short date is required by London Council for the. And my lord, while this proceeding is going on, they have issued tender notice.
Just a moment. You are saying that 9, 10 cannot vote.
Yes. They are nominated member by the government. For that section 11. Section 11. Section 11 of the Municipal Act. Subsection 2. Yes, your lordship, what am I?
No, once you are saying it, I am accepting it.
No, my lord. Your lordship will not accept my version. Your lordship will accept the statute.
It's okay. Once you say, we take it.
It's still I'm reading. Number of commissioners. Section 11. The number of commissioners of each municipal board shall be such that the state government may notification decide determine in this behalf. Provided that the number of commissioners shall in no case be more than 30
Now,
or less than 10.
MP and MLA,
Yes.
they can vote.
Yes, ma'am.
Yes, they can.
They can vote.
Because it is provided in the constitution matter 243.
3 and 4 can.
3 and 4.
3 and 4 can.
Yes. The state then matter subsection 2. The state government may appoint persons. Section 11.
What is the voting power?
Yeah, I'm more than half. It's, if there are 14, it should be 8. Now we'll also kindly come to subsection 2. Section 11.
No right to vote. It's okay.
Yes. No, the nominated by the government cannot, they can speak but cannot
It's
vote.
okay. Where is that voting power?
Well, that has been decided by one judgment of this court, Subal Rabha,
Yes.
where it was decided that the MP and MLA will be entitled. Probably there is an agreement in the bar. Subal Rabha case to decide.
Then it is there.
It is there. It
in
is
the
not there in
con-
the statute as such in so many words, my lord. But it has been decided by a judgment of this court in Subal Rabha's case, where it says that MP and MLA can vote.
Yes. I was also MP manner.
Where is the power of voting under the act? Just show me that power.
The power of
I think this section 11 itself is
No,
somehow.
not that. No, not a MP and MLA. But in the motion, confidence motions, the percentage of 51 you are saying, where is that?
Yes, it is in section 28, removal of chairman, section 28.
Section 28, my lord, that
Subsection 2. 9.
want to repeal it.
1 9.
Not less than half.
Not this has been amended, my lord. The book, all the books are writing less than half.
Now I am
It
telling
is
my
more
lord,
than
when it was amended. My lord, it was till 1919, actually, 2011. It was not less than half. In my lord, the more than half by Act of 2011, effective for 1905-2012. So from 1905-2012, my lord, it is more than half.
Okay.
My lord, with the permission of the court, my lord, may I just indicate one small thing, my lord?
They are less than half.
Yes.
My lord, the table has been turned the other way, my lord.
No,
They have
just a
fought-
just
Yeah.
a moment. We'll come back if
Yes.
required.
Yes.
Just not on merit.
Okay.
Not a merit, my lord.
I think.
Twenty-eight two says an elected member or chairman may be removed from office by vote in favor of which more than half of the whole number of commissioners shall have given their votes at a meeting.
Yes.
Whole numbers. Whole numbers would mean that if that all the members must be present.
Hold the member.
Whole members means must be present. Or is members present and voting?
No,
It cannot
it
be
is present in
and voting.
parliament, man. In the parliamentary assembly, 2/3 of the members present
Present
voting.
and voting. So this is not present and voting.
No,
That means 100% has to be there.
naturally that should mean, my lord. Actually, you know, my lord, if there are 14, my lord, The presence must be, if the motion will pass, my lord, more than half means at least 8. With vote.
No, eight members present.
Yes.
Can't be.
Yes, yes.
No, D28(2), but that's why I've read it thrice.
Yes.
Resolution member in favor of which is more than half of the whole number of commissioners shall have given their votes.
In elective
Quorum section, quorum, quorum.
Whole shall have given the votes.
Quorum, quorum. Page number, my lord, page number, section 46, because in some of the statutes, my lord, the quorum, if it is not fulfilled on a given date, then the next day, whoever is present will form the quorum.
Quorum is 1/3 for general meeting.
46, yes. Section 46.
No, this is not a business of quorum.
No.
It will not be covered by 46.
Maybe.
Special meeting.
I have not read, but just now I have seen.
Forty-six they have given, what is covered. It is not for 46. It's a special meeting
Yes.
for removal of chairman.
Yes.
Here it says whole number of commissioners shall have given their votes at a meeting. Mrs. Sharma will need your assistance
Yes.
in reading this.
28.
An elected chairman or vice chairman may be removed from his office by a resolution of the board in favor of which more than half of the whole number of commissioners shall have given their votes at a meeting specially convened.
Yes.
It's not present and voting.
Let me again read, my lord.
Which more than shall.
Shall have. This can't be interpreted to mean present and voting.
No, present, my lord, the word present and voting is not there, unlike in, my lord, parliamentary rules of business or the assembly rules of business, my lord. Here, an elected chairman, vice chairman may be removed from his office by a resolution of the board in favor of who is more than half of the whole number of commissioners shall have given, more than half number of commissioners should give the vote. Has given their votes at a meeting specially convened for the purpose. So some of them may not be present, madam. At least the 8 members must be present in the present case to vote.
Yes, okay.
Already, what I am on is, my lord, since my learned friend has pointed out the
Now the only question remains is that whether in the bar you will have consensus or have to pass an order. By now you understand what will be the order.
that was I was assuming, and I was also of the view that your lordship would do that. That your lordship will direct the.
No, what I do, I don't know.
Yes, I
But
know.
I'm asking.
My assumption, my lord, let me express, my lord.
But I'm asking whether you two have consensus or have to pass an order.
My lord, consensus may not be necessary if your lordship so desires. After all, it is your decision, your discretion to pass the order, any order, my lord. Either for, against, or in the midst. But what I was assuming, my lord, when I started the argument, that your lordship would direct both the party to be present and direct the.
No. No.
And
you hear the order.
fresh confidence mention.
You hear the order.
No.
Or your lordship is asking for protection of the case diary.
My lord, with the permission of the court, my lord, may I just indicate one small thing? My lord, the entire thing has been hijacked in a different phrase, my lord. They have called a meeting. Onus is on them to show. Suppose in case here they are counting that this much member present, I take a vote situation. No member is present. There no confidence motion fails. Onus is not on me to show that I am enjoying the confidence of the house. They will show that more than half has lost confidence on me. So counting the heads, 3 members present, 4 members present, it is It is not for me to show. My case is that I'm enjoying the confidence of the house. They failed to come up with the requisite number. Now, even if one member is present, it is they who has failed, because the act says they will have to show more than half.
Okay. My lord, lordship is disputed today or?
No, right now.
My lord?
I'm dictating the order right now.
Because it is a democratic process, my lord, the democratic process must be allowed to go. So that the no confidence motion called must go through the due process without any interference or hindrance, and the DC and SP and the OC must protect them to while they are in the meeting. Free and fairly. There may not be any force or any my lord, hindrance created.
Okay.
So it has to be.
Mr. R.P. Sharma, then senior counsel. Assisted by Mr. N.K. Kalita and counsel for the petition. This is 168.
D. Dole.
Once, no, sorry, Mr. D. Dole. I'm sorry. WPC 168 of 2024. This mistake I always make. I don't know why. Also heard. Mrs. S. Sharma Ranad, government advocate appearing for respondent number
126.
123. So 1, 2, and 6. No, district commissioner 1, 2, 3, 4, 5, 6. 1 to 6. Okay, okay. I was reading 1, 2, and no, it's okay. 1 to 2, 1 to 6. And Mr. M. Biswas, the council appearing for respondent numbers 7 to 10. The petitioners are the elected members of Silapathar Municipal Board. Full stop. Nine elected ward members made a complaint to the deputy commissioner Dhemaji, now district commissioner Dhemaji, ventilating their no confidence against the chairperson. Full stop. By letter dated 1/12/23, they ventilated their grievance. Full stop. This was followed by another letter dated 7/12/2023 for making an inquiry regarding the no confidence motion. Full stop. By a letter dated 12/12/2023, the district commissioner Dhemaji wrote to the chairperson, Silapathar Municipal Board, thereby forwarded the petition submitted by the ward commissioners expressing their no confidence against her and the chairperson, Silapathar Municipal Board, the office which is held by respondent number 7 was given 15 days time to hold the meeting from the date of receipt of the letter. Full stop. Accordingly, the Vice Chairman, Silabata Municipal Board, respondent number 1, by respondent number 1, had issued a notice convening special meeting of Silapathar Municipal Board, purportedly under the provisions of section 28 of the Assam Municipal Act, 1956. Full stop. The District Commissioner Dhemaji, by an order dated 4/1/2024, appointed Sri Biswajit Fukan, ACS, as representative of the, as his representative to attend the meeting. Full stop. Next paragraph. It is alleged that an FIR was lodged on 5/1/2024 by the petitioner number 2. No, who is Jogeshwar Kutum?
Father of Nityanandra Kutum, my lord, who was kidnapped.
Father of petitioner number 2.
Oh, petitioner number 2 was kidnapped.
Yes.
Okay, the Jogeshwar Kutum, the father of petitioner number 2, had lodged an FIR on 5/1/2024 before the officer in charge, Silapathar Police Station, alleging that the petitioner number 2 was kidnapped at around 3 p.m. on 5/1/2024 in broad daylight and is untraceable. Full stop. At the in or around the time of meeting, which was called at 2:30 p.m. on 5/1/2024, it is projected in the complaint dated 6/1/2024, lodged by the petitioner number 1, that while she was on way to attend the board meeting of Silchar Municipal Board, at around 3 p.m., she was dragged by the police personnel forcefully and forcefully through a police vehicle, and thereby prevented her from attending the meeting. Full stop. The said complaint was lodged before the Superintendent of Police, Dhemaji. Full stop. The petitioners, by representation dated 6/1/2024, addressed to the District Commissioner Dhemaji, ventilated their grievance against abduction of 2 ward members, preventing them from attending the board meeting held on 5/1/2024. Full stop. The meeting of the Silapathar Municipal Board was held on 5/1/2024 and and 6 ward members, as well as the concerned member of parliament and the concerned member of legislative assembly voted against the motion. Full stop. 2 other persons were present who were the nominees of the deputy commissioner, and
One was the representative of Deputy Commissioner Malek, the other two were nominees of the government.
Government nominees.
another was government nominee, and the government nominee was present.
And the
Who did not
executive
have the power to vote. Full stop. Accordingly, the motion failed, and the respondent number 7 continued to be the chairperson of the Silapathar Municipal Board. Full stop. Next para. Accordingly, by filing this petition under Article 226 of the Constitution of India, the petitioners seeking that the actions taken by the respondent number 7 and her men and agents be declared to be illegal and arbitrary, and to direct the respondent numbers 3 to 10 by abide by the legal provisions and not to cause any obstruction and hindrance in the conduct of special meeting of no confidence motion against the respondent number 7, and to restrain the respondent number 7 from making any transaction during the pendency of this writ petition. Full stop. The state respondents
CS by role.
the district commissioner, respondent number 3, has filed an affidavit in opposition on 23/2024 wherein it is stated that on the basis of written complaint received from the respondent number 3, who is respondent number 3? Okay, District Commissioner. On the. On the basis of,
DC.
he's referring to whose complaint, paragraph 13. Whose complaint he's referring to?
The petitioner,
Petitioner number one.
petitioner number 1. To the SP. Next page to DC. And the DC. DC, of course, there are 8
12.
persons signing.
Which page is annexure F 25?
Well, annexure. 20. Annexure page 27 and annexure G page
There's a
26.
mismatch of your annexure and the statement in para 12. Annexure F is your FIR of kidnapping of the respondent number 2. Statement in paragraph 12 is something else. On the basis of written complaint received by him, a report was sought for from the Superintendent of Police Dhamaji, who gave a report dated 8/3/2024. Beginning that at 9:45 AM on 5/1/2024, a meeting was to be held at Silapathar Municipal Board regarding no confidence motion. And it was anticipated that a law and order situation would arise. And on the same day at about 3 PM, a reliable information was received that one ward commissioner, even bracket name withheld, bracket closed, who is an FIR named accused in Silapathar PS case number 71 of 2022, along with the petitioner number 1, would participate in the no confidence motion and will come together in the same vehicle. And accordingly, in the Naka, they were stopped. But they refused to go to the police station and created a ruckus, RUC KUS. And therefore, the officer in charge of Silapathar police station, in order to control the situation, took them took the petitioner number 1 to the police station. And later on, when she was identified as the vice chairperson of Silapathar Municipal Board, she was released and she was not the desired person. Stop. Next paragraph. The respondent numbers 7 to 10 have also filed their affidavit in opposition. And it is projected there in that the copy of the letter dated 1/12/2023 in the subject of no confidence against the respondent number 7 was not served on her. In that after a lapse of 12 days, on the district commissioner by an email dated 12/12/2023, directed the respondent number 7 to hold a board meeting within 15 days.
Zero is not direction. There is no direction.
No, it is stated in this affidavit. Whatever he has stated, I am writing it. It is a direction. It can't be interpreted otherwise. It is not a request. Deputy Commissioner, if he starts requesting, they will have a what
What is the language?
go into depression.
Let me take again.
The district commissioner will go into depression if they have to request someone for something.
You are, in this regard, you have to convene a board meeting as per the provision of the law. That's all. It is not direct.
That's okay. He is writing something you. Mr. Vishwas may be advised how to use English. What he is writing, I am reproducing here. You read that paragraph 4. He says direction. Thereafter, the vice chairman by letter dated 29/2/2023 served on him on her. She's a lady. Lavanya is
Yes,
a
yes,
lady.
yes.
On her on 2/1/2024. Called a special meeting to discuss the remote confidence motion against respondent number 7. Yes. The the respondent number 7 has also disputed the power of the district commissioner under the Assam Municipal Act to instruct the chairperson of the Silabara Municipal Board to convene a meeting. And in this regard, reference is made to the provisions of section 43 bracket. Sorry, 43 of the Assam Municipal Act. And it is also stated that while the FIR lost for kidnapping of the petition number 2, no names were disclosed in the FIR, but in these petitions, allegations were made against the respondent number 7 to be responsible for the kidnapping. Hence, the lodgement of the FIR is also questioned. The senior counsel for the petitioner's side. He made his submissions in support of the writ petition. Similarly, the legal counsel for the petitioner has also made a submission, sorry, the respondent was 7 to 10 also put his submission in support of their contention. would not be necessary to burden this order with the nature of submissions made. Next paragraph. It would be appropriate to put the provisions of section 28 and 47 of the Assam Municipal Act. This one. As well as 296. The Learned Senior Counsel for the Petition contends that in view of the provisions of section 496 of the Assam Municipal Act, the district commissioner has the power to has the supervisory power over the municipal boards constituted under the Assam Municipal Act. And therefore, the said authority had the sanction of law for issuing letters to the chairperson and the vice chairperson of the Assam Municipal Board to hold special meeting for the no confidence motion. We are unable to accept it, accept the said submission in view of the provisions of section 296 of the Assam Municipal Act, which does not grant express power to the district commissioner to issue directions to either the chairman or the vice chairman to hold a meeting to discuss the no confidence motion against the chairperson and the vice chairperson. The provisions for removal of chairman and vice chairman is contained in section 28. Is quoted very before. This one. It has been stated at the bar that while Assam Municipal within bracket amendment, bracket was Act from 2011, 11 and 12, the words not less inverted commas appearing in subsection 2 of section 28 has been deleted and substituted by the word more, inverted commas more.
More than half.
Next, as on this submission. Okay, I think the time is already up. I may not be able to take up other matters. The dictation will go on for at least 10 minutes.
Now.
Huh? So no, this way I have to excuse others. All are waiting. I don't want them to wait. If there is any interim order, please tell the court master. Otherwise, in other matters, we will not give a date right now. Those will be leftovers. But if there is an interim order anywhere, please tell it to the court master. Interim orders, if any, will be extended. From the From the scheme of subsection 2 of section 43 of the Assam Municipal Act of 1956, the chairman or in his absence, his or her absence, the vice chairman is required to call for the special meeting. As per section 28(2), the removal of the chairman with vice chairman is to be to a specially convened meeting. Full stop. So therefore, such a meeting is only required to be called on a requisition made by not less than 3 commissioners. Full stop. Therefore, we do not find anything contained in the Assam Municipal Act of 1956, which empowers the district commissioner to entertain any application made by any ward member in respect of removal of chairman and vice chairman. Stop. Therefore, the district commissioner shall also not have any power even to make a request to the chairman or vice chairman to convene a special meeting for the removal of chairman and vice chairman. Therefore, on the issue as to whether the district commissioner has any power or authority to convene, to issue any direction to the number 1, municipal boards, number 2, chairman, and number 3, vice chairman, to hold a meeting for removal, a special meeting for removal of chairman and vice chairman. Stop. From the scheme of section 43(2) of the Assam Municipal Act, only on requisition of not less than 3 members, special meeting can be convened either by the chairman or in his absence, or in his or her absence, the vice chairman may call a meeting, special meeting, and under subsection 3 of section 43 of the Assam Municipal Act, if the chairman or the vice chairman fails to call special meeting to meet within 21 days after any such requisition has been made, such a meeting is permissible to be called by the persons who have signed the requisition. Therefore, the manner in which the meeting was convened cannot be said to be a valid exercise of power, but said to be in valid exercise of power. Next one. We now deal with the issue of the alleged kidnapping of respondent petition number 2, and preventing the petitioner number 1 from attending the meeting. In this regard, we find that the officer in charge of Silapathar police station was aware that a meeting of the board was to be held. As per the report of the Superintendent of Police, Banaji, addressed to the District Commissioner by letter dated letter number is 70. Right. Comma. There is a mention in paragraph 2 thereof that a meeting of Silapura Municipal Board was to be convened on 5/1/2024 at 9:45 AM. Full stop. There is no document on record to show that the meeting was convened at 9:45 AM. Full stop. If the meeting was to be convened at 9, if it is accepted, but the meeting was to be convened at 9:45 AM. There was no necessity for the police to have a NACA check made at 3 PM. Full stop. Therefore, when there is a specific knowledge of the officer in charge of Silapata Police Station that a meeting is convened at 3 PM, comma, you have petitioner number 1 arrested and are restrained from attending the no, only one. She was the only one.
But and later on, she was found not excited. So not what.
Let me pass you on. And public restraint and removed to Silapata Police Station by not allowing her to attend the board meeting. And thereafter to make identification. And then to have it confirmed that she was the vice chairman of the municipal board. Itself shows high-handedness on part of the officer in charge of Silapata Police Station. To have a person detained in police station without verifying the identity. To stop. The said action cannot have the approval of the court. And this has to be deprecated as the police personnel had interfered with the functioning of the Silapata Municipal Board by restraining the respondent number 1, the petitioner number 1 from attending the board meeting. If the police has specific information that some person is an accused in a proceedings and is a ward member who is attending a municipal board meeting, so the arrest could have been prevented, could have been postponed till the such ward member. In this case, till the ward member comes out of the meeting. First off, when the officer in charge of police station, Silapata Police Station, has information of the board meeting, he is also supposed to be aware that the meeting was convened at the directions by the district commissioner. Imagine. Next one. This observation of the court shall not be interpreted to mean that elected board member cannot be arrested while going to attend or while coming back from the meeting. This observation is specific to this case alone and is not to be construed as a law laid down by this court in this regard. Full stop. This observation is made only when it has been brought to the notice of the court that 2 board members were prevented from attending the meeting. Next. Therefore, comma. When the initiation of the no confidence motion against the respondent number 7 is not found to be in accordance with law. And at the same time, the intervention of the district magistrate, the district commissioner, Jhamati, and the handedness of the officer in charge of Silvata police station cannot be approved. From here, the bottom line is that there is no bar under the Assam Municipal Act. We have a once again lay down a no confidence motion against any officer if such because such motion is not barred. However, they make clear that if that whatever actions that are contemplated must be strictly in accordance with the provisions of the Assam Municipal Act from 1956. And the prescription of law must be adhered to. Next.
My lord, if such meeting is called, my lord, that decision especially ensured.
If you have said so, they will now understand. I don't have to say them.
Because the orders of the courts are very.
Lordship, we have seen very serious allegation
They are
against them.
ultimately the custodians of law and order.
Yes.
That's why in this.
But this your lordship may express expectation that they will maintain at least. Otherwise, this one meeting. So in view of that, your lordship finding that so-called proceeding initiated by them on the same no motion also goes.
So this one, as we have said so, can be honest.
That your lordship.
No, because that's already
Yes.
According to the. But you see. Please come
One
to
said
your
it
prayer.
is illegal, one said this
No, no,
it is
please come to
illegal.
your prayer.
Hello?
Please come to your prayer.
I have come to cause that also. In
Please
second
come
day.
there. You've not made anything. You've not.
Hello?
There's no specific prayer.
Where?
Come to page 16 of your declaration. You see, there's no prayer.
The lordship only come to WPC 1526.
So that is separate proceeding. But here we are not.
No, at the time it was not passed. They have produced later on when they filed the affidavit counter, generally you come to know such a proceeding was manufactured later on. That's why challenge in second petition.
So that's okay. When we pass an order there, but here we are just stopping at there.
Yes, even lordship is separately dealing with the 168 WPC, then the different matter. In second petition, we challenge that so-called
No,
proceeding.
there we are not passing an order. We are giving him time. We are not passing an order. Here we are giving him time.
That's
1 week's time to respond.
Only that observation I wanted my from lordships for the answer of justice that
Observations contained. The observations I expressed hearing before. This repetition stands closed.
On the floor.
Then in 1526. Same. Order is same of the parties. Of the parties are same. Or the prayer made by the 11th Council for responding number 7 to 10. 1 week's time is granted to file affidavit in opposition with the matter. Yes, sir. This time. 10/5/2024.
1 minute.
10/5. Yes. It's 7 days time. You get 2 days time to.
And my lord, any transaction made.
No.
No.
Challenge.
What I mean, there is two-fold prayer. So that.
No, whatever action is, you see, Mr. Sharma.
Yes.
Let us say I am an employee, a grateful employee of the municipality. You are the chairman. You sign a bill for my salary.
No, I am not on this. You'll also kindly come to tender notice. Only the persons who are with her, they are only allowed development in not our wards, my lord. Other 8 members are deprived. You'll also kindly come. to the second petition.
This was never challenging your.
Will also kindly come to page 42.
Page?
Annexure J, in the second petition,
Page
42. Page 42. Single person is allowed 2-3 works, my lord. You also kindly ward number 6, ward number 10, ward number 3, ward number 3, ward number 3, ward number 5, 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 ward number 6, ward number 11. And our wards are totally excluded from the development scheme. What is this?
I'm not following you. Please explain again.
Your lordship, those ward commissioners who are with the chairperson are given 2-3 works. And our wards are, our 8 members, 7 member wards are totally excluded.
But I don't see anything
That
in
we
page.
don't
What
know.
do
Those are-
you
those
see?
are proceedings
Ward
that
number
you-
6?
No. Those are, you see, proceedings, which have to be.
This is totally illegal matter. This is by the executive officer which can be passed under section 60 and 61. These are board's meeting.
No, we can't, we can't give a.
My lord?
Ban right there.
My lord?
You see.
I am army illegally married. It is up to your lordship to accept or not to accept my illegal submission.
We're not granting anything to you.
But at least your lordship will observe my lord, any transaction made shall be subject to the outcome of the petition.
No, it's tender. Ultimately, you see, these tenders will have to be assailed.
Yes, I will accept this one.
Notice inviting tender,
Yes,
19 February.
yes, I will accept that one. Our wards are totally excluded, no development scheme. We are going high and dry in front of our voters. They should fair distribution, the government largest cannot be disputed to favorite ones only under law.
We're not granting a stay.
At least your lordship may observe that any.
Make an observation, but not to that effect. I'll just record your here.
My page to watch it is illegal, it is without passing in the board's meeting matter, without government sanction. No.
Next, I this is the senior counsel for the petitioners have pressed for an interim order in connection with notice inviting tender published on 15/2/2024. And in this regard, it is submitted that the works for which tenders, the said tender was issued only involves the specific wards who are where the ward commissioners are in favor of the respondent number 7. So accordingly, it is submitted that with no development work or activity is taken up to the said tender in respect of the respective wards of the 8 petitioners herein.
That's all.
The issue regarding the activities of the board has to be raised in the Srinagar Municipal Board. And if the tenders was issued illegally, at this stage, the interim orders against the tenders cannot be passed for the reason that the opening of the tenders was scheduled on 28 to 2024. And by this time, almost 2 months have crossed by. Mr. Sharma, if you're asking me to pass some observation, it will make your reputation infructuous, because then I have to say something which will go against your interests.
On
Because you
this,
see, the next line which will be coming is that as to the, it is not within the competence of the court to say as to which development work should be taken up.
no, that I'm not there.
No, because you see, you are saying that the.
No, I am only on my, because we are elected ward commissioners. We also have.
No, I
some-
understand, but you see, now for the court to decide that in this part of footpath of High Court near the Ganesh Mandir, why work is carried out, why in the other road?
My submission only fair distribution of the government largest,
It's
that
okay,
is.
but it is not.
Otherwise,
within our
I am
competence.
not demanding anything from your lordship.
No,
What is under the,
Is it within our competence to decide as to which work should be done, where should be done? And what to be done?
no, that is not within your competence, my lord, this I know. But what I know is that whether that was sanctioned under section 61 and 60 of the.
That you can see if it was.
Yes, let it be known there, where it is.
Let me see. So, the anxiety expressed by the learned senior counsel for the petitioner is that the works which were tendered were not appropriately sanctioned in accordance with
Section 60 and 61 of the.
Section 60 and 61 of the Assam. Yes. Needless to say that if the necessary sanctions were not there, or the authorities were calling for the work, are doing so at their own risk. And therefore, this can, the petitioner can have this, those acts independently examined. Allow the law to take its own course. However, as the court finds that the works which are tendered are developmental activities from any interim order to stop development work would not be in public interest. And therefore, court is disinclined from passing an interim order at this stage when the tenders have already been opened. The tenders were slated to be opened on 28 to 2024 at 3 p.m. However, this observation of the court shall not preclude the court from passing orders on bail when the matter is heard.
Today, at least, my lord, one law has been settled, my lord, because that.
Whether that is settled or not, that I will again seek decision from our court, my lord, whether this to be, in other cases, whether it directly or addressed to Deputy Commissioner Chairman, then I will seek review.
Pardon me?
If your lordship's decision, I find, is not correct to the decision already decided by this court earlier,
That may happen.
then I will seek review.
Yeah,
Obliged, my lord.
that may happen.
Yes.
That may happen because you have
Because
not searched.
your lordship has power to correct it also.
Because we have not searched.
Yes.
No such details.
Definitely, this power is already, that is the beauty of the art of lawyering and the, what you call the justice delivery system.
Yes.
Where if you make a mistake, there's no, no
Yes, yes.
difficulty in accepting that we have made a mistake.
Similar thing was happened while in the Justice Ranjan Goel's court when he was sitting singly here earlier. In a service matter, he passed the order, denied us. Then I sought review. And then he admitted that yes, the judgment given earlier was wrong and I reviewed it.
I have accepted it.
Yes.
There's one of my.
Yes, that
judgments
is the
where I have
beauty
accepted
of,
my mistake.
beauty of the judicial system.
But as far as this point is concerned, my to whatever little I have researched, my there is, I could not blame.
You see,
No,
that is
there
why
is no such also I have
it is-
said, matter that it is.
there is
that
a-
is
there is a
clear.
difference between.
Let us find out, let us have the
It does
research
not
on
say-
the
It
subject.
does not say conclusively.
Yes.
He says that if he finds that he will do it.
Yes.
So if he finds that tomorrow
But
comes.
earlier also we used to
We'll also
address
learn.
to the deputy
This
commissioner.
tomorrow
Yes.
comes. we will
The reason was my lord, the addressing to the deputy commissioner, that there is. Yes, all I learned.
Yes, what happened to your matter? It never came.
Today, this matter was finished.
The matter has come.
Yes.
Item 47. Who is the other side?
No, Lordship.
The government.
Not,
Ms.
no,
Sharma.
government is.
Ms. Sharma, please be here for a moment. Here we impose a cost on him. He has gone to Supreme Court and the Supreme Court has observed that if he seeks an apology, it should be reconsidered. But Mr. I hope learned counsel for the applicant. Oh, sorry, for the petitioner. This. This matter has been listed at the instance of the learned counsel to the petitioner. Next one. This could be order dated 1/12/2023. Had dismissed. This CRP IO 380 of 2023 at the motion stage without issuance of notice on the respondents. However, on the ground that that an attempt was made to mislead the court, the court had imposed a cost of rupees 20,000 on the learned counsel for the petitioners to be recovered from him. And to be paid to the Guwahati High Court Bar Association, we made a part of the Benevolent Fund. Was agreed by the said order. The petitioners had moved the Supreme Court of India by filing an SLP, which was registered as SLP within bracket civil, bracket diary number 756 of 2024. This one. The notice of however by order dated 8/1/2024, the said SLP was dismissed. No, not dismissed. No, while special leave was granted. In respect of the cost of rupees 20,000 imposed on the learned counsel for the petitioner. The Supreme Court of India had made an observation that if the advocate tenders a written apology before the learned single judge of this court, the single judge would take sympathetic view by passing an appropriate order to stop. Pursuant to said directions from the advocate of the for the petitioner has filed an affidavit and the said affidavit sworn on 27/3/2024 has been changed by the registry before the court. By the said affidavit, the counsel for the petitioner is tendered unconditional apology. Next, having heard the counsel for the petitioner from his unconditional apology is accepted. And the observations and directions contained in paragraph 7 and 8 of the order dated 1/12/2023 wherein cost of rupees 20,000 was imposed and the Guwahati High Court Bar Association was permitted to initiate recovery if the amount was not paid within 1 month stands expunged. This according to the petition, the counsel of the petitioner did not pay the cost imposed. This order shall be read together with order dated 1/12/2023. CRP IO 380 of 2023.
Your lordship has fixed that whether on 10th or 10th, I will be in Arunachal alone, 9th, one day before I will inform the. Just one day, this side or that side. 10th and.
The court, Mr. Collector, would be here only because I want passing an order in the absence.
Well, I'll inform because he was.
If he's there, call us, I'll come over. You tell the court master, I'll come. You need not be here if I if it's the.
Highly blessed. Highly blessed.